Hello. It is my great pleasure to welcome you all to the University of St. Thomas Law Journal Spring 2024 Symposium, Emerging Issues in Sports Law. My name is Michaela Bitts, and I'm the editor-in-chief of the Law Journal. More importantly, though, I'm the first place finisher in our Law Journal's March Madness bracket. So with that said, I'd like to welcome to the stage the 7th place finisher, our symposium editor, Marshall Kellner.
All right, thank you, Michaela. March Madness pools are great because truly anyone can win. Truly anyone. In all seriousness, Michaela has been great to work with on this event. Thank you for all your help. Also, a special thanks to our co-sponsors for this symposium, Stinson, along with Fafinski, Mark, and Johnson. You'll hear speakers from both of those firms on our second panel. And thanks to Law Journal members Mason Rademacher and Joe Maney for their help with the dinner last night. That went great. Thanks to all of you who attended that as well. Also, thank you to Professor David Granardo. He's been an absolute pleasure to work with every step of the way on this event and helped recruit many of the great speakers who you'll hear from today. We started planning this symposium last summer, and it's so exciting to see it come to fruition. Sports law is one of the most interesting and talked about areas of the law, and you will soon see why. Today you will hear from well-respected scholars from all around the country and here in Minnesota. We have professors, attorneys from private firms, and team counsel. For those of you in from out of town, welcome to Minnesota, and to everyone, welcome to St. Thomas Law. A brief rundown of the day. Panel 1, in a few minutes, features 4 of the most prominent sports law professors in the country discussing the state of college sports. Panel 2 will discuss the state of representing clients in sports law with some of the private firm attorneys. Panel 3, the professors will return for an Ask the Sports Law Expert session over lunch. And you see pens and note cards on your tables. Feel free to submit questions for that panel and submit them to the registration table in that red box that TJ Bowman is holding up right now. The final panel, on panel 4, we will hear from attorneys representing the Minnesota Vikings, Twins, and Wild. Thank you all so much for being here today again. And with that, I'm pleased to introduce the Dean of the University of St. Thomas School of Law, Joel Nichols.
Thanks, Michaela and Marshall. I appreciate that. It's so great to see all of you today. I'm Joel Nichols, the Dean at the University of St. Thomas Law School. If I haven't met you, look forward to doing that over the day. For those of you who are students, great to see you. Thanks for being here early this morning. I'm sitting in the sunny atrium. It'll be nice and warm, but don't worry. I know that the speakers will not help make you drowsy today. So no need to worry about that. I did notice. I wanted to start off by thanking Professor Granardo. I just want to riff on Marshall's comment as well. That the first panel, I was looking at the program again, has 4 of the top sports law experts in the country and Professor Granardo. So I don't know. I mean, he didn't say it that way, but that was the implication, David. So I'm just noticing. But to circle around a bit, to tell you just a little bit about who we are at St. Thomas, and to remind our students, but our guests. Yesterday in this atrium, we had even more tables, and we were packed out for our annual Mission Awards ceremony. The time when once a year we come together and celebrate not class rank, not best grade, not those things, which are great. We celebrate them like every law school does, but what is it about our community, the gifts that each person brings that makes us the place that we are, right? And one of the first so we'll do service and community, we'll do professional preparation, living the mission awards, different things, and different people in the room. We're nominating others among them, and we're receiving them. But I thought it was especially appropriate, right preceding this event, that the students were awarding David Granardo an Excellence in Professional Preparation Award for his work in engaging in the classroom, in his scholarship, in the way that he serves in this space. And I think today's symposium is an excellent example of that kind of connection. And it's tied so well to the next, the two people who introduced the program so briefly, Michaela and Marshall. And to me, I know them both personally from my time teaching in the 1L. I was happy to know them and before that and outside of class. But I also know that they're really emblematic of the students that we have here, of all of you, and the excellence that comes together. And we're a stronger place and institution because of people like Professor Granardo, all of you as students, and those mission awards and the time together, I think, really highlight that. And so just to flag how proud I am of all of you to be at a place where it's easy for me as the dean to stand up in settings and say, for the second year in a row, we're in the top 100 in U.S. News. Every year, we are right at the very, very top of the practical training rankings for the work that we do that connects not just the head work, but the on-the-ground work that we're going to do as attorneys. That we're in the top 15% of the nation, top 25 schools for the scholarly impact that happens out of this place. So I love being in a place where I can just rattle them off time and again, but I return to the undercurrent, which is it's the people that make it great. It's the relationships that we build, and it's the space and culture that we create, and that's because of you. And so as I think about the program that we have today and the connection to sports law, you did not invite me to speak, which is good because I'm not a sports law expert, and it also means my time is running out. Marshall will start quickly holding up time cards at me if I don't stop. But the themes that we're going to see today, I think, are going to resonate with this undercurrent of relationship, right? It's not just the business of sports law. It's the joking that we're doing ahead of time, where our lives are intertwined with each other in work and in play and in engagement, right? And sports is one piece of that, but it's also a business in its own right. It's also regulated in so many ways that we get to step into, to notice, to watch, to participate. It's got these great themes, right, that echo what we do at St. Thomas of individual success, striving on your own to be the very best that you can. But in so many sports, if you do that on your own, the whole team's not going to succeed, right? You do it in the context of everyone else. It lines up so well with what we want to do here in this space. So I'm glad that you joined us. As I step away, I'll just make one passing remark. As the sun is beaming through the windows and we see that the glass and the beautiful day we have outside, I will say just to our guests what our students have heard me say before. I love sitting in our atrium because I describe the architecture as these arms that come out from the side that envelop us with a sense of welcome. And this sense of glass connects us to the community, but also encloses us here for the work that we're doing before we're sent out to connect further with it. And so I hope that you as guests feel that deep sense of welcome and hospitality, just as I know has happened as you've been engaged along the way and hosted so far. Welcome again to St. Thomas. I look forward to seeing you throughout the day.
If you want to, you can either stand or sit. But I'm gonna introduce. Yeah, that's tradition. Yes. Good morning, everyone. You guys have the program. I'm Professor Granardo. I'm not going to read through all of these incredible speakers. I will say that when we were planning this, Michaela told me that she has a friend at Creighton Law School, and they're also doing a sports law symposium, and they told her, You took all the best speakers. These are all those best speakers. And one of them, Walter Champion, he's on the way, but let me start with Professor Davis, Timothy Davis. Just point out a few things. He's the Bess and Walter Williams Professor of Law at Wake Forest University School of Law, former chair of the Law and Sports section of the Association of American Law Schools, which is for all the law professors in the country, received his BA from Stanford University and his JD from the University of California at Berkeley School of Law. Also, when I started writing articles on sports law, this is the person that I always cite. He's incredible in so many different areas of sports law, somebody that I look up to as a scholar and a professor, so it's amazing for him to be sitting here today with us. Go next to Matt Mitten, who is a professor of law and the executive director of the National Sports Law Institute and the LLM and Sports Law program at Marquette University Law School. I also have to mention in my sports law class, these are two of the co-authors of the book that we use. This is the Mitten and Davis for the folks who are reading those cases and are in those classes. He's an arbitrator for the Court of Arbitration for Sport.
You can blame them, yeah.
in Switzerland, American Arbitration Association and JAM Sports Program, as well as the UFC and Professional Fighters League anti-doping panels. Graduated from Ohio State University and got his JD from the University of Toledo College of Law. He's testified before congressional committees regarding various sports law issues. The very first sports law article I wrote on why college athletes should get paid, I presented at Marquette Sports Law because of Matt. And he wasn't able to attend that presentation because he had a guest, Bud Selig, who's the former commissioner of Major League Baseball, and Matt thought he was more important than me, so he went to that. I'm just kidding. But afterwards, Matt spent an hour and a half with me on trying to look at my article, add things to the article. So I really, really have always appreciated that. Tremendous. All right. And as hopefully Walter Champion will be walking in here pretty soon, let's get to Maureen Weston. She's a professor of law at Pepperdine University, Caruso School of Law, and director of the Entertainment, Media, and Sports Dispute Resolution Project. She received her JD from the University of Colorado and a BA in Economics, Political Science at the University of Denver. She also grew up in the same hometown as my wife in Pueblo, Colorado, and she was Miss Junior when she was in Colorado. She's taught law at the University of Oklahoma, University of Colorado, UNLV, Hamlin, and in Oxford, England. A frequent speaker at conferences. She's a co-author also of casebooks on sports law and arbitration and has written numerous articles in the area of Olympic and international sports arbitration, disability law, sports law, and dispute resolution. So what we have for this panel, and remember, these panelists are coming back for the Ask the Experts. So if you have questions that you already had prepared for them, great. You can also come up with questions based on what they're saying here today. So each individual is going to come up, maybe present for 5 to 10 minutes. They're going to have a conversation on that for the rest of the time. There's 20-minute slots. And then that's an incredible panel. So we're going to go one by one, and then at the end, even if you have questions, great. If we get to them, wonderful, but know that we can get to them at the noon hour. Okay, so we'll start with Professor Davis. And Xander, if you could pull up those slides. Xander's 10 steps ahead of me. And I will hand it over to Professor Davis. Thank you.
Thank you, and a good morning to everyone. First, I'd like to thank Marshall and members of the Law Journal, Dean Nichols. I know deans support the Law Journals, and also, of course, Professor Granardo. When I was invited, I almost didn't come because April is a very busy month for me. I chair the contracts drafting committee for the, we write the multi-state questions for contracts. And we had one of our 2 yearly meetings last weekend, and I thought I can't do something else immediately following that after having looked at about 250 multiple choice questions over 2 days sitting in a room. But I said yes because of Professor Granardo and his invitation. I followed his work, and as I was thinking about this earlier, as I near the end of my career, It's nice to know that more experienced folks like the panelists are going to hand it off to someone like David. He is a great professor. I follow his work and respect his work a great deal. My colleagues are going to focus a lot on legal developments in college sports. I thought I'd set the stage by just giving you some things to think about with respect to the impact on these various changes on student athletes and student athlete well-being. I've listed here on the PowerPoint slide some of these changes that have occurred, and they're really transforming and restructuring college athletics. You have court decisions, which I know the panelists will talk about with respect to O'Bannon, the Austin case, the Johnson case, which is before the Third Circuit. You have conference realignment. What's the impact of that? It will certainly result in more money for certain schools, but what's the impact of that on student athletes and student athlete well-being? How about the expansion of the football playoff? Will that have a positive or a negative impact on student athletes? It will certainly generate more revenue, but what will be the impact on student athlete or college athlete well-being? You have the athlete NIL rights. I support athletes having the right to profit from their name, image, and likenesses, but at the same time, do the positives outweigh the negatives? And if there are some negatives associated with it, what can be done to try to counterbalance the negative consequences of NILs? And then you have transfer rules. Transfer rules have been great for student athletes. They, particularly in football, men's and women's basketball, baseball, because for a long time, they were the student athletes who had a more difficult time transferring because the one-time transfer exemption waiver did not apply to them. And so it's been beneficial, but at the same time, we have what's called transfer flipping or portal flipping. And does that have a negative impact on student athletes? And then we have legalized gambling, and some of you probably heard about prop betting. All right, none of these changes are going to go away. But again, we need to begin to think more, I think, about the impact of these changes on the student athletes and their well-being. And I look at it and frame it from the perspective of role identity theory. And each of us serves various roles. I'm a professor, I'm also a spouse, I'm also a father, I'm also a friend, I'm also a colleague. And so we serve these different roles. And role identity theory posits that the more these roles that we serve, the more beneficial. For example, the easiest way to say that the more roles that we perform, it gives life more meaning, more purpose. Also, we get social reinforcement from the various roles. And within college sports, what you find is that there's always been a tension. There's always been a tension. I will figure this out by the time I sit down, right? There's always been a tension, and that is between the athlete role and the student role. And so when I look about the changes, some of the changes that were set forth in that first slide, I think about how will each of these impact the student athlete from the perspective of, will it make the athlete role more salient, or will it make the student role more salient? Will it have a neutral impact? It may have a beneficial impact in one way, but have negative impacts in other ways. So there's always been this tension within college sports because what we tend to see with respect to student athletes is that the more that there has been a focus on the athlete identity of student athletes, there can be negative implications of that. It can lead to increased isolation, increase mental issues, and other things. I have a slide on this that we'll take a look at later on. And so looking at NIL, for example, great benefits. And so from one perspective, NIL can be viewed as expanding the identity of student athletes because student athletes are performing in a different role. They become entrepreneurs. They try to market their brand. They can learn very valuable skills that are associated with that. At the same time, the question emerges, are there some negatives with respect to NIL? Will it in fact enhance the athlete's identification with the athlete role? We also have here some of the other implications of the changes, and that is, to what extent will it result in a contraction of the student-athlete role? For example, you look at conference realignment, and that's going to increase the travel time on student-athletes. And what will be the impact on that with respect to their focus on academics? You look at some of the other changes, the transfer portal, which again, I think is a good thing, but also transfer flipping. There's some negatives associated with that because it increases the anxiety on the part of many student athletes as to whether or not their coaches will push them away from their team, and what happens to their scholarships, because scholarships are not portable from one university to another, athletic scholarship. But the bottom line is this: the more student athletes are engaged in activities that place a greater emphasis and therefore make the athlete role much more salient, the more potential issues that result from that. And so on this slide, I have things I want you to think about, because we're going to have my colleagues are going to talk a lot about the legal developments and some of the issues that emerged from the changes in college sports that were presented, those 5 or 6 changes that were presented on the first slide. But one of the things I want you to think about is look at each of these changes within the context of the potential issues that arise when athletes begin to identify more closely with their athlete role rather than their student role or any other roles that they may have in life. Because even student athletes have the role of a friend, they have a role of a child, and so on and so forth. And so again, think about these questions that I pose here. I'm not sure that the answer will always be yes with respect to each of the changes that has occurred and will continue to occur in college sports. But again, this is more food for thought as we go through the presentations today. Thank you.
Well, good morning, everyone. It's really a pleasure to be here, and especially to be on a panel with Professors Champion, Davis, as well as Professor Weston and Granardo. So one of the first sports law conferences I spoke at goes back to, I think it was 1993. Professor Champion at Texas Southern hosted it. I was at South Texas College of Law, Houston. I had the pleasure of meeting Professor Davis, who was at Southern Methodist. And I know Professor Granardo was at St. Mary's for a long time, so it's kind of a homecoming. And Professor Collette, who's on your faculty, we both started at South Texas College of Law back in 1990. It's amazing how quickly time goes with things.
Scaring them.
Yeah, it goes quick. As someone who realizes they graduated 40 years ago. So I'll jump into my presentation here. Apologize for forgetting my blazer. Professor Davis and I were emailing back and forth yesterday morning about wearing a tie. Well, I brought the tie but forgot the blazer, so that's why I'm dressed like this. So what I'm going to talk about is how courts have been applying federal antitrust law to input market restraints like student-athlete eligibility rules. And this kind of ties a lot of things together for me because I started out practicing law in 1984. I was an antitrust lawyer, and Board of Regents just came out. That's the case that you notice in the title here, it said Justice White's amateur education model. He dissented. Anyone know who Justice White is? Yes, he was a very famous college football player, finished second in the Heisman Trophy voting, went to the University of Colorado. Saying that's where Professor Weston went. So how does this work? Yeah, like this?
Down button.
Down button. Oh, I went too far. Okay, so let's talk a little bit about this case. Those of you who are college football fans might be surprised to know that about 40 years ago, there was only 2 games on Saturday afternoons, and that was it. And that was because the National Association, the NCAA, sold all the college football television rights for all the schools. And that was successfully challenged by the universities of Oklahoma and Georgia on behalf of what are now, well, it used to be the Autonomy or Power 5 conferences, now it's the Power 4 conferences. And that was an output market restraint that was found to be illegal. And this was really the first time the Supreme Court addressed the application of federal antitrust law to college sports. And now we have the benefit of, you could probably watch any game that you want on college football. It's not only Saturdays, but other days of the week. And there's some important dicta in there. The majority had said, well, college athletes must not be paid, must be required to attend class and the like. That's kind of what's come to be known as the amateur educational model. And Professor Davis, in one of his early articles, pointed that out. There was a very strong dissent by Justice White, and I think Justice Rehnquist joined him. And his main point was basically that we ought not treat college sports like professional sports. College sports are very unique. There's no other country in the world that has a system that ties higher education to high-level athletics. And among some of the things that he pointed out, and let's see if is this happening today? He says, we don't want to apply antitrust law in such a way that it prevents institutions, or we want to prevent institutions, the bigger schools that are more successful, more alumni. I went to Ohio State, we have 600,000 alumni, from taking advantage of their historical success by expanding programs. You know, we'll talk about conference realignment. That's kind of what's driven a lot of this. And want to keep university athletics from becoming professionalized so that the profit-making objectives would overshadow educational objectives. So it's a little bit different. You know, it's clearly the NCAA is an association's nonprofit, as are its member schools, but there's a very significant commercial aspect to it, but I don't think we want to commercial or professionalize it. So what basically happened from 1984 really up to 2021? So after Board of Regents from 1984 to 2015, virtually all of the federal appellate courts were aligned, and essentially student athlete eligibility requirements, like you only get in-kind compensation in the form of an athletic scholarship, not pay for play, where there were antitrust challenges to that and other related things. Courts basically said those types of restrictions were per se lawful. They either characterized them as non-commercial restraints, not subject to federal antitrust law, or it was presumed that the pro-competitive effects of things like maintaining competitive balance, amateurism in college sports, preserving the educational aspect outweighed any anti-competitive effects in the form of reducing economic competition among universities for athletes' services. Well, I had started writing a little bit about this article, and I kind of went back. I hadn't done this in years. And as a former antitrust lawyer, 30 years ago, I had said, well, wait a minute, this is commercial activity. That was one of my first articles. 5 years later, said, well, you shouldn't presume that this is pro-competitive. There's clearly the reduction of economic competition among schools for student-athlete services, and any restrictions to be lawful should be the less restrictive means of promoting interbrand competition, which is distinguishing college from professional sports. But then about 10 years later, I started thinking about going, hey, commercialization is inevitable. And that's fine. That reflects that we're such, big sports fans for college sports. And started thinking about the idea, well, maybe Congress needs to intercede here because there's certain, the non-economic objectives that basically don't count for purposes of federal antitrust law, as Justice White pointed out. So then keep going too far ahead. So then what happened, and really up until 2015, when the Ninth Circuit in the O'Bannon case which was very interesting case. It was originally a NIL or right of publicity infringement suit. Ed O'Bannon, who'd been a basketball player on one of UCLA's national championship teams, recognized that this, any of you play the probably too young, but there used to be a game, electronic arts, college football, or basketball games, and athletes weren't getting any of the revenues from it. So they brought and won an NIL rights infringement suit, and then there was an antitrust challenge to the school's rule that said student athletes couldn't earn any NIL rights income. And fairly complicated case that went to trial, but the bottom line is the Ninth Circuit basically said that any kind of restrictions at the national level on the value of a college athletic scholarship below full cost of attendance were unlawful. The trial judge said that, well, it wouldn't reduce any consumer demand for college sports if college athletes got roughly $5,500 in revenues schools could provide, a type of revenue sharing. But the Ninth Circuit reversed that. They said, well, any kind of benefits untethered to educational benefits are unlawful. So that was the first federal appellate court case that kind of went against the grain on saying that these type of student athlete eligibility restrictions, amateurism rules are per se lawful. Then coming ahead to, interestingly, the Supreme Court denied cert in O'Bannon, but the court did accept cert in the Alston case, which was decided in 2021. I think it was late June. This was a unanimous decision. It didn't have really anything to do with NIL rights or whether any kind of restrictions on pay for play, schools providing student athletes violated antitrust law. It had only to do with restrictions on educational benefits that individual schools and conferences could provide to student athletes. And the bottom line on this one, all 9 justices agreed that there shouldn't be any limits on in-kind educational related benefits like microscopes, laboratory equipment, musical instruments, and that any cap below, and it's interesting, this was the same court out in Oakland, same judge, Judge Wilkin, she decided that, well, if schools are permitted to decide to give schools up to almost $6,000, it was basically the $5,500 plus a little bit for inflation, that so you could provide cash benefits for making grades, educational bonuses. Any national limits or limits between 2 conferences were unlawful. But then there's this strong concurrence by Justice Kavanaugh, where if you read this, he basically suggests that college sports is no different from professional sports. So under his view, it's like, well, there ought to be a commercial professional model. So what has happened since then? We literally have an avalanche of antitrust litigation. So, well, right before that, so the NCAA member schools, of course, are very concerned about antitrust liability after the Supreme Court's Alston decision. So rather than coming up with hard and fast NIL rules, they came up with guidelines, which basically said, 1, comply with the law of the state where the university is located, because there was about 30-some states enacting these NIL rights laws. 2, any NIL compensation, which is determined by fair market value of the athlete, can't be used for recruiting purposes, and it cannot be paid for play. They were hoping to stem antitrust litigation, but the opposite has occurred. So very quickly, there was a suit brought by athletes who said, well, the fact that the association is now permitting student athletes to receive fair market NIL value indicates that this amateurism, as a pro-competitive objective is no longer valid. That's the House case. They're trying to get treble damages going all the way back for 4 years. That's been certified as a class action pending before Judge Wilkin, who was the O'Bannon and Alston trial court judge. The Fontenot case in California is Colorado, basically challenging any kind of restrictions on pay for play. And then Ohio versus NCAA recently struck down limits on second or subsequent transfers. So it's total free agency now across all sports. Tennessee versus NCAA said that, well, use of any NIL prohibitions on that for recruiting, that is unlawful. So now with collectives, we again have the Wild West, so to speak. And then finally, the Brantmeyer case, which was just recently filed, this is a challenge to the rule which would prohibit individual performer sport athletes like golfers, tennis athletes from winning prize money and maintaining their intercollegiate eligibility. So there's some amateurs playing in the Masters. If they win and this suit's successful, they could keep that. So just real briefly here. So where are we at? Courts, looks like, are applying federal antitrust law based on a commercial professional model of college sports. So we've entirely shifted. Essentially, where we're at is that virtually all NCAA association-wide or divisional internal governance rules are per se illegal, except for perhaps rules of the game, as well as possibly equipment regulation, health and safety requirements. Justice Kavanaugh correctly observed that, well, yeah, there's some difficult policy and practical questions that are occurring. How do we resolve that? One way might be legislation, which Congress hadn't gotten around to, collective bargaining, which Professor Weston will talk about that as an option, or some other negotiated agreement. Maybe in questioning, I can bring up Professor Stephen Ross and I came up with a proposal that would, if Congress would adopt it, would maintain the commercial educational model via Federal Regulatory Commission. So thanks. I think I kept it to like 12 minutes or so.
That was great. That was great. And what we're going to do now, we're going to shift it to Professor Champion, as he's going to talk about the Alston case, the concurrence. And let me just introduce him. He wanted to make an entrance. Was that it? Well, so Champ, he is a professor of law at Texas Southern University School of Law, Thurgood Marshall in Houston. He was formerly the George Foreman Professor of Sports and Entertainment Law. He has taught over 100 sports law or sports-related courses. He's written about 80 law review articles and 13 books, and he's writing a couple more books, 2 of them with me, I believe. No, I know that for a fact. He's an amazing professor, and we're very happy to have him. So take it from here, Walt.
How y'all doing? It's good to be here. I apologize for being late. I had a really bad hair day, but it wasn't my fault. Y'all walked me, 10 miles yesterday, up and down. So the fact that I'm here at all, God is good. Thank you very much. My name is Walter Champion, and I think I had to be a sports lawyer because champion on sports law, what other opportunities do I have? And just wanted to say, for example, halftime football, long time ago, the coach made this Newt Rockne speech. Not one of you can look yourself in the mirror and call yourself a champion. And I said, I can, coach. And he elbowed me in the head. So that started me with the CTE. I mean, I knew that CTE was going to be out there. And another thing that happened early on, I was there with my dad watching a Phillies baseball game in 1957 when the great Hall of Fame batter, Richie Ashburn, hit a foul ball and struck a little old lady. So, okay, that's one thing. While she was being taken out on a stretcher, he hit her again. That's back control. And that's why he's in the Hall of Fame and you're not. So, and I turned to my dad. I was a 6-year-old kid. And I said, Dad, what's happening? He said, well, son, you don't see that every day, which I think may be the understatement of all time. But that also got me involved in thinking about sports law, even at age 6. I knew I was going to be here one way or the other. I brought my book, Sports Law in a Nutshell, as an arbiter for any disputes we might have. They all have a lot of books, but mine's the smallest one, the most compact one, so we can use it that way. Let's see, as he mentioned, Professor Granado and I are writing 2 books, The Teaching Sports Law, and I found out after really teaching it over 100 times, and NCAA compliance and boxing in the law, which is not necessarily an oxymoron, all sorts of courses like that, recreational injuries. I kind of came to the conclusion that the best way to teach sports law is to have Major League, the movie, on a loop. And so it has all the contract issues in the world, and it's really great that way. We're also writing a book called Reconsidering Sports Law. It's fiduciary relationships, the greedy corporations, and the workers' rights. The first time we thought of this, the editor said, well, this is great for the subset of Marxist sports fans, which I thought was a little impolite. So we're doing that stuff. And I just wanted to comment about, what was said about before the Board of Regents. Under the old rule, the NCAA demanded that Hofstra v. Eastern Michigan generate as much interest as, let's say, Ohio State v. Michigan, which is patently absurd. Ohio State and Michigan must have, what, 1 million alumni? Probably. And Eastern Michigan Hofstra has, what, 100, 200, something like that? So I'm saying there's more interest, and this kind of like let things, open, in that way. Now, one thing we panelists have done, although they don't know about it yet, is that we're coming up with the best acronym for the NIL. The most popular one is Now It's Legal, which I think is pretty good. I came up with, I think, one that might be a little more interesting. NCAA is lobotomized. What do you think? Thumbs up, thumbs down. We're working on it. It's a process. It's a process. And we had talked about, the concurrence of the Justice Kavanaugh. Only thing I really thought about him was that he liked beer, which is probably impolite and rude, and I apologize, but his concurrence is like one of a kind. Usually when it's 9-0, you don't have a concurrence. And he kind of went off, which is really, really interesting. So to me, in my mind, it's before the concurrence and afterwards. And the concurrence kind of changed anything. And you're absolutely right that this was a strong statement. You have to get your act, in order, or we're going to do other things about that. I've never seen anything like that in my life. 9-0, we're not going to see for a while anyhow, but a concurrence that strong is just the precedent. If you want to go back a little bit, the Supreme Court usually have gotten sports law wrong. I mean, I think we can all make that statement. In the federal baseball case in 1922, Oliver Wendell Holmes, the junior, was thought to be a great judge, said that antitrust is not involved in baseball because it doesn't have anything to do with interstate commerce. Well, I'm not really good on Civ Pro and constitutional law and all that other stuff, but I'm thinking the Philadelphia Phillies are in Philadelphia, which is Pennsylvania, and the Chicago, the White Sox and the Chicago Cubs are in Chicago, which is in Illinois, and when you travel from state to state, that should be interstate commerce. He says it's not related whatsoever. So we got it really, really, really wrong, and to even still, baseball has an antitrust exemption. What other entities has an ongoing, complete antitrust exemption? Nobody. Maybe in like World War II, if you made the plastic for tanks, you might get one for a couple of years, but no one has that. And so this just, once again, in my view, why the Supreme Court and many of the courts have gotten sports law wrong. Of course, you all know that Abner Doubleday founded the baseball. He did not. That was just a jingoistic marketing tool that they came up with. After the Civil War, we all have to get together, even though we hate each other horribly. We're going to do it by baseball by making this myth. History becomes a legend. Legend becomes myth. So this was what I'm dealing with. And I say maybe I do have a Marxist view on sports law in my old age. I don't know. I hope not. But this is kind of how it began, and you can just look at the Supreme Court over and over again, how they have gotten it wrong. Flood v. Kuhn. Who's ever read the case of Flood v. Kuhn? Your hands are all up, right? Yeah. Anybody? You gotta read it. It is like the most amazing case in the world. Absolutely the most amazing case. I think if they could, they would put the pop-up art, somebody hitting a home run and maybe the scratch and sniff is the most unusual case ever. The Justice Blackmun this is one of the first important opinions he had. He's also doing Roe v. Wade at at the same time. So what he was doing was going to the Supreme Court library every night to midnight, and they're saying, oh, he's going to really write Roe v. Wade really well. He knows how important it is. Ignored Roe v. Wade and just concentrated on Flood v. Kuhn. Didn't even concentrate on the opinion. What he concentrated on was coming up with the greatest list, the 83 greatest baseball players of all time. So this was like the stats before they had stats. What is the earned run average in 1884, stuff like that. So he's using the baseball encyclopedia midnight every night. And, so he came up with his opinion, which starts out with the poetry and stuff like that. And once again says that Abner Doubleday founded baseball, which is an incredible lie. But anyhow, he was going on with poetry and stuff like that. Usually don't see a Supreme Court opinion beginning with 3 pages of poetry. I'm just saying. And bad poetry, too. It's not even good poetry. So, so that type of stuff. So he came up with this list of 83 greatest ball players. And Thurgood Marshall, to his ever-ending credit, he said, hey, there are no African-American ball players on that list. And so Justice Blackmun said, well, it's only up to 1950. And I would like to think that Justice Thurgood Marshall at that time walked away and said, that's my point, because no African-American ball players were allowed. I mean, racism in baseball and other sports was absolutely complete. So I think hopefully he just walked away and he said, okay, if you add a couple African-American ball players, I may vote for your opinion. So they added the 3 ball players, and once again, Justice Thurgood Marshall did not vote for that opinion, and they came up with dissents that were really good. One of them from the Justice Douglas was, this is a derelict in the stream of law. And all they said was that, derelict in the stream of law is really, really cool. And it's a gangster type of thing, derelict in the stream of law. I think it's really cool. But anyhow, so that was what was going on at that time. And it just like makes my point that Supreme Court rarely gets sports wrong. Right. They really, really get it wrong, because to them it's still, is it a sport, is it a recreation, or is it a business? They're still having that problem. I'm saying that if Ohtani can make $700 million a year, it's got to be a business. I'm just saying that. I mean, that's might be a bold statement. And I'm saying if Jimbo the Fisher can get a package of $77 million to not play football, you give me $1 million to not teach, and I'll walk off the panel right now. So $77 million. Anyhow, I think we all can assume that it is a business and a very important one. So these are kind of the backup things, and I still think that NCAA is bottomized is a pretty good one. NCAA beat Austin 9-0. To me, I was thinking about this for a long time, since like 2016. A little bird was in my head saying the NCAA is about to go under. Now, there was no reason to think of that. In 2016, they were stronger than ever, but there were little things happening. And I was coming up with this, writing on, a little piece of paper, this time the sky is really falling in for the NCAA. And with Northwestern was able to, their athletes were able to be viewed as an employee for a while, and then that got turned down. But little things were happening, and there's like a buzz, They're about to go under. They're about to go under. Now, prior to that, the NCAA was unbeatable. In Tarkanian, over and over again, they were unbeatable. And I'm not saying they're evil. I'm just saying I heard once that the president of the NCAA had a little mole on his head that looked like 666. I'm just saying that's what I heard. I think it's a vicious rumor, and I don't want to get sued for it. He's not alive anymore, so I won't get sued. But they really did not seem to, am I going too far? They really did not seem to care about the welfare of the athletes. What do you think? I mean, I don't know. I also can bring up other things that they paid $40 million for 2 words, March the Madness. That's, to me, that's, something's going on. Anyhow, these little words, these like little, hey, the NCAA is going under, came to me, and it was like getting larger and larger and larger. And with O'Bannon, that was a huge step. And then with Alston, that was even a bigger step. And with his, the concurrence that Justice Kavanaugh had, he's just like opened it up completely. I mean, was this expected by any of us?
The 9-0.
Yeah, well, 9-0, but then that concurrence was, it was just like, am I reading this, is this like, in a different language, if I have into a portal in outer space?
It was gratuitous.
Yeah, it was. Read that, okay? Or have a good faith effort too, how about that? Yeah, law students love that. Yeah, we have a good faith effort, yeah. After 2 or 3 of the bottles of wine, we have a good faith effort. We might read it, we might not, but we'll have a good faith effort, sure. So that's kind of what, kind of opened up. And there's other things that went with it. For example, the Dartmouth basketball players are trying to be viewed as employees. And now, with the NIL and the transfer portal and the realignment of conferences and the TV rights, it's going to be hard to say that these people are not employees. It's really going to be a different thing. It's the duck theory all over again. If it waddles like a duck, if it quacks like a duck, it's probably a duck. So these people look like employees in every other way humanly imaginary. And what he came up with in Kavanaugh was that the NCAA is not above the law, which we always assumed that they were, we just kind of assumed that. And he actually said they are not above the law. First time that there was ever a statement that bold, because quite frankly, everybody was afraid of the NCAA. I mean, maybe that's unkind or whatever, but I think that's probably correct. And so it's not above the law. Long restricted to compensation and benefits as a student athlete may achieve. But this is only dealing with the narrow rules restricting the educated related to benefits of student athletes. And he's saying, okay, we got that far. It's like the nose of the camel in a tent. Once it gets in there, the entire camel is going to be there ultimately. And that's what he's saying here. These values have historically restricted student athletes from receiving money from endorsement deals and the like. In the old days, you could have great college athletes not getting enough food to eat. I mean, that literally happened. And that's, quite insane. I say the bottom line is that the NCAA and its member colleges are suppressing the pay of student athletes who collectively generate billions of dollars in revenues for colleges every year. This is a model that is nowhere else in the world. As we talked about, no other civilized country in the world has anything like that whatsoever. And I think one thing that's going to happen out of this with the NIL is that athletes are going to actually continue in school. What do you think of that? Whoever would thought that would happen, right? And if they can make more of the money and the less chance for injuries in school, why not, God forbid, graduate from college? I mean, why not? And no other entity, no other civilized country has anything like it whatsoever. In England, if you're a good football player, which of course doesn't mean football in the context we have, you can join the Premier League at 16 and all those other things, but you can't do that here with the rules that we have. So was a really interesting opinion. The concurrence is just like one of a kind. I'm using another word. It's the comeuppance against the NCAA. In other words, the NCAA was acting up for years, and so this is the comeuppance against them. Slow down. Realize what's going on here. And I think it's just quite amazing, the one of a kind. And luckily, it doesn't have the poetry or the list of the 83, the greatest athletes of all time. Must have took him hours to go through that, looking at the stats and stuff like that. And, how much is a 355 batting average in 1888, that type of stuff. I would think he had better things to do, but I'm not one to attack him right now. And they also, the only line that the NCAA used was that we have a history of the amateurism, which is really important. That was over to dicta from Board of Regents, and that was their whole argument. I looked at, and it shows you I have no life whatsoever, I looked at every amicus curiae brief, and it must have been 20, I read all of them, and their basic thing was we have a history of amateurism. And they only got it from Overton Dichter in Board of Regents, and that's it. That was their whole argument. So it wasn't going to work. And with this court, with this unusual 9-0 group of individuals, it wasn't going to work at all. And, that was their only argument. NCAA has acknowledged the rules discourage athletes. This is good too. They actually acknowledge that the rules discourage athletes from the graduating. I think that's absolutely correct. They isolate athletes from graduating, and they isolate athletes on campus away from friends and family. They also deter any athlete from starting a business or writing a book. This is not normal capitalism. This is not what we should do for the athletes. 80% of all football players are broke within the 2 years. 80% of all professional athletes are broke within the 6 years. Something's wrong there. I mean, I can't figure out why, but I think this is a good start. I think it's an excellent start. And, I really urge you, good faith effort, to read the concurrence. I like you all too much to tell you to read the Flood v. Kuhn. You can look at all the list of the 83 greatest athletes, but that's about it. And am I doing all right on time?
Yeah. So I think we're good. I think we're going to hand it over to Professor Weston, and Professor Weston's going to take us home with all of her thoughts, I believe, on the employee cases and NIL cases. And if we have time, I'd like these four giants of sports law to talk with each other about the things that they've heard, but also understand that if you have questions, you're going to have time over the lunch hour to answer those questions, and if you want, to respond to what your co-panelists have said here today. But you have time, Professor Weston.
I just want to quickly thank everyone and St. Thomas. But Professor Champion, this has been fascinating to hear from you, and your hair does look good. But yeah, that's right. But to your point, I've said as I read these cases, judges are fans first, it seems. Like, why does the Supreme Court, which is divided on every issue, all of a sudden it's 9-0, all of a sudden they're in favor of the little guy, the employee rights or the rights of the consumer? I haven't seen that anywhere. And even in 1922, the federal baseball case saying baseball, it's keep your laws off by baseball. It's sacred. That's a sacred place when you go to Target Field. The law shouldn't apply, is what the judges are saying. And even when you read the beginning of the Alston case, what doesn't get cited much is Justice Gorsuch talking about, well, we're not going to return to the day of the paid ringer. Have you noticed that? People always cite Kavanaugh's statement, and then there's also language in there, and we're not going to have Lamborghinis. It's education related, but we're not going to talk about Lamborghinis. But do we have Lamborghinis now? Because this is the current state of college sports. Right, we have conference realignment. We have USC, UCLA going across country, talk about impact on student athletes of traveling 3 time zones. My Pac-12 has blown up. There's sports gambling, prop betting, pressures on athletes. I'm a buff, so Shedeur Sanders making more than his dad, most likely. And so we're seeing this NIL, and things have exploded since Alston was an education-related benefit decision. But meanwhile, the states were already enacting these pay-to-play laws, which were going to be in effect 2 years later in 2023. As soon as they saw the 9-0 decision by the Supreme Court, they fast-forwarded within a week and started implementing the NIL laws. And the NCAA was just had to relent at that point. We're seeing this emergence of collectives, which weren't really anticipated or discussed much when we were talking about the NIL, right? It was the idea that, well, student athletes should have the same rights as other athletes to go out and have a YouTube channel, or Jeremy Bloom should be able to get endorsements for his skiing, just treated like everyone. But now the schools are now partnering with the collectives, and now the collectives are essentially de facto the recruiting department, because the schools are not to be involved in NIL, but it's all a big sham and it's blowing up. There's an effort to call, this is commercialization, and why don't we pay the players, having the schools directly pay the players as employees. So are they student athletes? Is that even a term we should be using? Or are they employees? And given the rights of employees, the responsibilities of employees, and their efforts, we saw Dartmouth, there's an unfair labor practice charge, essentially treating them as employees at USC. And we've had the history of this idea of student athletes, if there are employees, should they be able to unionize like we have in the pros? Or does this pose an existential threat, which is what some of the legislators, the Congress people were talking a few weeks ago. I think Matt was testifying there as well. But what are the implications of that? So if you consider a day in the life of a student athlete, the whole idea is that the emphasis is on the student, and then the athlete, you're participating in your sport, but to have the balance of the sport and education. And then if you look at the actual schedule, if you talk to a student athletes, do we have student athletes here in the house? Pretty much your schedule, you have to get up, or there's a very regimented schedule, and it goes late into night, practice sessions, and then of course you have to get on your social media and do your brain. Think of the appearances. Caitlin Clark, in addition to doing all of her, being in school and the competing at the highest level, just such excitement there. She's doing commercials. She has, they're doing their NIL. That's a whole side hustle that they're allowed to do, but just think of the finiteness of the day and their ability to do that. So the NCAA has, and the intent of the NCAA will say, we are all the NCAA. Every educational institution, conference, we're part of the NCAA, and we make the rules together. So over 1,200 colleges, and they're not all the same. We have Division I, and then we have the powerhouse football conferences, and then the other Division I, which doesn't even have football teams, and D2 and D3. So it's a broad base of educational institutions, and you do need to have some type of governance structure. Now, maybe it's just going to be at the conference level, but to determine what the rules of play are, the eligibility, and so the NCAA has been charged, and even the big conferences, the SEC says, oh, NCAA regulate the eligibility, and then you get sued while we get all the football money because of Board of Regents. So, but in this, the rules, one of the fundamental principles is this idea of amateurism, and that they're student athletes. And behind each one of these rules, you can be cynical, but the people at the NCAA that we know from Indianapolis, they're good people. They're working for the benefit of college sports, and each one of these rules is intended. Maybe it doesn't, and maybe it's impressive and evil, but it's intended to benefit the student athlete and to provide fairness across the board, and limitations on practice hours are supposed to be to benefit the student athlete, so the coaches aren't there saying, you have to come and do all these different things. So I'm on athletics council. I was at OU and also at Pepperdine, and they're looking out for the interests of the student athletes. Is that paternalistic? Is it exploiting them? But that's the idea. But meanwhile, when you do see these, March Madness, the massive media contracts that are happening with the realignment, you have to say, well, that's good, but should the students be getting more? That dicta that athletes should not be paid has been the mantra of the NCAA, but does it make sense when there's such big money in some sports? And that's the thing. The NCAA is a lot of institutions, and we tend to focus on the power sports. So if the student athletes are regulated in their day-to-day, right? Are they employees under the law? So what is the test for determining whether a person is an employee versus an independent contractor? And we surprisingly go to common law definitions, but is that definition applicable to the range of laws that are available to employees? So state workers' compensation, minimum wages and overtime, unionizations, think of the other areas, Title IX, Equal Pay Act, Title VII, the taxation, and the right to be terminated. And the contention that student athletes are employees has not just, it's not a new development. In 1953, the widow of Ray Dennison, who died on the football field, sought to get workers' compensation benefits from the University of Denver. And going through that system, the Colorado Supreme Court said, well, what's the definition of an employee? And right to control, you have to show up, and they provide the equipment. So it's common law definition of employees. So they said yes. Well, the NCAA saw that at the time, and here's where we can go, like the subversive. They said, well, now let's intentionally call them. Walter Bowers has said, we intentionally crafted the term student athlete to emphasize the student because they were afraid of an onslaught of cases claiming benefits under workers' compensation and other employment laws. And there have been other cases seeking workers' compensation at the state level, and essentially it's by state. So Colorado may say yes, but that may, and California actually put in their state labor code that student athletes are not employees, and so it's varies by state. The Waldrop case, the court says, well, let's apply the employee test, and they said that applies, but the jury found, they just deferred to the jury on that. So that varies by state law. And then federal law, the range of federal laws, we have the National Labor Relations Act, we have the Fair Labor Standards, we have the EEOC, which enforces Title VII, the ADA, age discrimination, the Office of Civil Rights with the Title IX, and OSHA. I was thinking, what are the employment laws? And suppose a football. There's so much litigation. It doesn't surprise me that someone will file a claim with OSHA saying football is dangerous. They make me hit each other. So I don't know, but beware. There's so many things coming out of the woodwork. So the Fair Labor Standards Act applies to employees. It's a federal law that guarantees minimum wage and overtime, and requires the employers to keep records, provisions on child labor standards, and it applies to employees in the private sector as well as the state and local governments. And once again, there have been cases, so we have a potential circuit split coming because the Seventh and the Ninth Circuit have both found that student athletes are not employees under the Fair Labor Standards Act. But this is their reasoning. Student athletes, this is play, not work. And it's a voluntary extracurricular activity, and this tradition of amateurism. So cases, as Professor Champion said, up until 2016, the courts, there was really just deference to the NCAA rules. And so, this kind of sacred notion that athletes should not be paid and that they're not employees. So the Dawson case also said they don't expect to be paid, well, because they can't. And there's no proof that the school can hire and fire them. So this is part of their educational experience. Well, we have pending, and it's been pending for over a year at the Third Circuit. There's a new thought now since Alston and the NIL legislation. The Johnson is a Fair Labor Standards Act case as well, where Division I players they're suing under the Fair Labor Standards Act, and they're saying, you schedule us to the nines all day long, and the travel and the time that we play, that's all work, and we're entitled to minimum wage for all of this because it is work. It benefits the employer, the university, and we're entitled to overtime for all of the time that we put in to our work as athletes. And so the Department of Labor this is where the Chevron deference case can have an impact as well. And I'm wondering if that's one of the reasons why the Third Circuit is holding off on issuing a decision. But the Department of Labor has a regulation or a provision that says student participation in extracurricular activities such as sports, band, debate, drama does not result in an employer-employee relationship. So you have the Department of Labor, but does a court need to defer to the Department of Labor determination on that, or simply apply the test for employment? And so what's happened in the Johnson case, the district court did find in favor. They denied the NCAA's motion to dismiss, and they applied this test, basically right to control or who's the primary beneficiary. So, but the district court did say that the plaintiffs can go forward and prove their case. And it's unusual on a motion to dismiss, the civil procedure here, on a motion to dismiss, it generally means, okay, the case just goes forward. You don't have a right to review until a final judgment. So, but the Third Circuit granted a request for an interlocutory review and held a hearing last February. And then they've also since asked for additional briefing on, well, how we decide how will this impact Title IX? How will it impact scholarships? And so we have the Seventh and Ninth Circuit older cases, and then we just don't know. So this is what, when you're going to be graduating, you're going to be dealing with these cases. But then if they are employees under the Fair Labor Standards Act, then this law applies to public and private institutions that will all have to pay their athletes over minimum wage and overtime. And how many schools can afford to do that? What is the impact? We can talk more about that. I want to get to the unionization cases. So the National Labor Relations Act is another federal law, guarantees workers the right to unionize, to strike, to engage if they're to form a union, and to require that management, the owners, to engage in collective bargaining. So that's the National Labor Relations Act, but it applies only to private employers. And so in the Northwestern case, they sought in 2013 to form a union, the Northwestern men's football team, and it went up to the regional, so it's parallel to the Dartmouth case. It went up to the regional director in Chicago, who applied the definition of employee test in this case and held yes, but it also went up to the national board, which I think what Dartmouth wants to do now. And at the national level, in the Northwestern case in 2015, the board basically declined to exercise jurisdiction. They said even if scholarship athletes were employees, asserting jurisdiction would not promote labor stability. The nature of sports leagues includes a number of public schools and conferences which are not subject to the NLRA. And besides, we've never had a situation where players competing for the team, one would be unionized and the other wouldn't. So it wouldn't effectuate the policies of this law, and we're just gonna step down. A few years later, under the Biden administration, out of the gate, the new general counsel, Jennifer Abruzzo, issues a memoranda that says, basically it's an unfair labor practice to call college players student athletes. They are employees, and bring it on. Bring me that case. So it's going to be considered a misclassification. Athletes are under the control of their services. Oh, right here, we have it right here. And so the invitation was accepted. The Dartmouth men's basketball team sought to unionize, and they got to that regional level, and the regional director said, yes, there's a lot of control here, in terms of the athletes they're just like employees, so I'm going to, the regional director said, yes, they are considered employees. Then the men's basketball team voted 13-2 to unionize. And that case is going up now to, Dartmouth is refusing to bargain with them, so they're going to take it up it'll go to the national board and then possibly through the courts. Also, I didn't know that anyone can file an unfair labor practice. So you have in the background these unions waiting. Now, the service union is going to be certified, with Dartmouth, and then the College Athlete Players Association. They just filed an NLR. You can go on the website and just file a ULP, an unfair labor practice charge, and they cited against the practice charge against USC, UCLA, and the NCAA. But the UCLA is not a private institution subject to the act. The NCAA, are they an employer? And what they're trying to do now, and one of the reasons in the Northwestern case, when they said that Northwestern's the only private entity in the Big 12, so that the other schools would not, or the Big 10, the other schools would not be subject to unionization. But then they're saying, well, if we apply a joint employer theory, so if we say that the NCAA or the public institutions who work with the NCAA jointly employ the athletes, then that's a way to bootstrap this up to to make it subject to the NLRA. So what would unionization do? This is the debate, and they're saying we have a right to come to the table. We, just like anyone, other employees, to discuss our working conditions, practice, travel, negotiate wages, which include part of the money that's earned on this. Now, Dartmouth doesn't earn money, the men's basketball team, and they're part of the Ivy League, which has no athletic scholarships, which is also being challenged. But should we just have pure free agency? So same thing that's happening. The National Labor Relations Board is pending, in the appeal on the USC case is also pending. So the question is, well, we don't have these decisions. The courts are holding off on deciding because of significant impacts if they are considered employees. And so we have arguments in favor, and then the other questions as a practical matter: how will this impact Title IX? Most schools, most student athletes don't generate money. Of the I think it's maybe 25 athletic programs actually earn money, are in the red, but most schools can't afford to pay student athletes. There's a question on will this impact, will schools have to shut down other sports? How will the pay be distributed? Does the quarterback get more than the wide receiver, and who's going to throw who the ball? Now they work this out in the professional leagues, but if you do this school, what's the league going to be? And so these are a lot of questions that I want you to tell me about. But is the solution, this may be a solution for the few, but not for all? But if the law is the law, if an employee, this is the test. And so I'm like, is this really the test? The NCAA is trying to get Congress to act. Good luck. But they've had endless hearings, Matt's at most of them, but they wanted an exemption saying that student athletes are not employees because the whole slew of laws that apply in this case. The NCAA new president Charlie Baker has proposed to create a subdivision where the schools, like a super division, where those big rich schools can just have direct NIL payments to the players and then pay all to assuage Title IX, pay everyone, all the athletes, at least $30,000. I'm not sure where that's going to go, but if they're employees, then they have their rights under all of the other laws. And I'll stop there and look forward to your questions.
So, very good. Excellent. So if you ever moderate a panel, just take the advice of my oldest son. He just said, "Let them cook, Dad." These folks are fantastic. Now, we haven't heard, so I know that Matt and Professor Mitten and Professor Davis limited their comments in time. So I want to open up the discussion to those two. You all know I'm a big proponent of paying college athletes, but I'd like these two to start with, what are the dangers? What are the dangers and the issues? Professor Davis did a great job of outlining a number of them, but if a college athlete is considered an employee, What are the dangers there? If antitrust, remember, antitrust law is about competition. We want competition for the inputs in terms of, are we competing for the athletes? Are we paying them competitive? Are the schools competing with each other to pay these athletes? And we will also want it in the outputs. The output is the game, because antitrust law is supposed to help the consumers. If you have two companies and one company you only have one company, it's selling the product, and it can charge as much as it wants, and it can have whatever quality it wants. Now, when you have two companies, typically the price is going to go down and the quality is going to go up. With the NCAA, we talk about the member schools and they're paying college athletes. It's not a monopoly, it's a monopsony, where the buyers control the market. But can you guys talk about whichever aspect of that? What are the dangers if antitrust law says, no, the colleges can pay the athletes directly, or the dangers of athletes are considered employees?
Even though I teach sports law, I also teach contract law. And for me, I began by looking at the potential dangers from the perspective of contract law. If they're deemed to be employees, will this be treated as your typical employee-employer relationship? And would an institution be able to terminate a student athlete? What would be good cause for termination? So I think it would result in an overall change in the nature of the relationships, perhaps even the obligations. But it goes the other way too. Under what circumstances could an institution sue its student athletes? I mean, we've never seen that happen before, to my knowledge. And so, again, I think we'd have to consider that aspect of it, the just basic fundamental contractual aspect of the relationship if student athletes are deemed to be employees, particularly because even if you look at it from the perspective of the NLRB, and some student athletes been able to unionize, but still there are contractual aspects to that as well, but only in the guise of the collective bargaining agreement. But again, I'm concerned about that aspect of it.
Yeah, just to pick up with that, I think there's a way of letting student athletes share in the very substantial commercial revenues that are generated by college sports without professionalizing college sports. Because as Professor Davis mentions, once you characterize them as employees, there's a whole host of, what will basically become contractual issues. Under federal labor law, wages, hours, other terms and conditions of employment, both sides have a duty to bargain in good faith. That doesn't mean either side has to agree to anything. And antitrust law doesn't require the parties to agree to anything either. Antitrust law is prohibitory in nature. It can't be used to tell the parties what they can do, or here it would be the universities, which do collectively have monopsony power as the sole demand for student athlete services, largely because with football and basketball players, not only NBA and WNBA, it's because of the restrictive requirements. You can't go straight from high school to the NFL, NBA, or WNBA. So that's really an important factor which really gets overlooked. It's the collectively bargained restrictions on who is eligible to play in the major professional leagues for those sports. In one sense, the NCAA and its member universities and conferences would benefit from unionization because of what's known as the labor exemptions. Anything that is in a collective bargaining agreement would be immune from antitrust challenge. But I think there's another area of federal law that we haven't really talked about, tax law, which could come into play. Because then you have an argument that every economic benefit that intercollegiate athletes get because of a, quote, employment relationship is subject to tax law. And right now, the in-kind value of an athletic scholarship is not subject to tax law. So I think most intercollegiate athletes would be worse off if they're paying taxes. The other thing is schools are going to say, hey, let's just have the sports that pay for themselves, enough sports to comply with Title IX, and then everything else is a club sport. And I don't know too many intercollegiate athletes who want to do that. So it's an incredibly complicated matter. I think Congress ought to create a federal regulatory commission where all sides are heard, and then they come up with a proposal that they don't mandate. It's just that if it is adopted, that would provide antitrust immunity. So it's incredibly complex, to say the least.
I have a short follow-up, and that is that if student athletes are characterized as employees, it's going to result in a major restructuring. Something along the lines, you may have heard about certain of the conferences, the Big Ten and the SEC have been talking about a separate body, a separate conference, and I think we'll see the move towards, certainly see the move in that direction. And whether that be good or bad, I guess it depends on whether or not you fall within the favored few or outside, right? Exactly. And those of you who may have loyalties for particular institutions, I'm at Wake Forest. It's very competitive in certain sports, but those are not necessarily the revenue-producing sports. So would Wake Forest be among the favored few in this super league? So we'll see.
And let's hear if I know we have just a few more minutes now, but know that if you have questions based on what these panelists are saying, please take them back to the registration desk there. And just a couple minutes to Professor Weston, Champ, do you guys have any quick responses to what was said or any other thoughts to add, knowing that we have more time at the lunch hour?
Well, one point I forgot to make is the impact on international student athletes and their visas. They can't even get NIL deals, let alone be considered employees. So that has to factor somehow or be addressed in this legislation.
Isn't there a one-arm basketball player who's able to get the NIL? I believe there is, yes.
Probably, yeah.
So that may be a subset, a very small subset. I could go on for comments for hours. Just going to say a couple things right off. Boise State will give you a free Ram truck. That's it. Thank you. I'll end on that.
All right, we have 1 minute left, and as you can tell, these folks, as you maybe heard this from about other professors, that they've forgot more law than I'll ever know.
He's talking about me, by the way.
But with me, actually, the students say that I forgot a lot of law, so I'm not sure where that goes. But anyway, we have the break coming up, so we have until 10:45. The restrooms are in the back right on every single floor. So if you want to take a break, we're going to be back at 10:45. Remember, these sports law experts are going to be back at 12:30. And any questions that you guys have, they'll answer. And there's a big red stop sign, so I will stop. Thank you.
Okay, perfect. My name is Hallie Cooper. I'm a 3L and a senior editor on the Law Journal. Our next panel is the state of representing clients in sports law. We have 4 different panelists, and they all work in private practice representing college and professional athletes. We have a big mix. I will be moderating a Q&A. If anyone has questions throughout, feel free to raise your hand. We have a microphone we can bring around, and then I'll also reserve about 15 minutes at the end for any last additional questions. It's going to be pretty informal, just question and answer, and we'll get started. I'm going to have all the speakers please introduce yourselves, talk about your background, and talk about the work that you're doing in the sports law industry.
Good morning. My name is Scott Erickson. I'm a partner at a law firm called Stinson. Used to be Leonard Street and Diner. We merged like lots of the law firms seem to be doing these days. I have a sports practice, but I also do a lot of other things. I'm really an outside general counsel for lots of privately held, closely held businesses. I've got a tax practice and estate planning practice, do a lot of succession planning. The fact that I have a really broad background really helps me with the sports work that I do. I've done outside counsel work for the Timberwolves, the Wild, special projects for the Vikings. I've just come off my 10-year term on the USA Hockey Legal Counsel, and then I'm the outside counsel for the United States Hockey League, and I've been the outside counsel for 22, 23 years. That's where the young men 16 to 20 go and play. Oftentimes to then get D1 college scholarships. Some of them jump right to the NHL or professional hockey in Europe. It's a very vibrant league. We have 16 teams, and one of the teams being the Olympic development team in Michigan. I've also represented a whole series of sports executives over the years, oftentimes helping them get a position, usually president, CEO types, and I've done that in the NFL and also in the NHL. We've also done some arena work, mostly in Minneapolis, but we worked on the Target Center when Glenn Taylor bought the Timberwolves. We worked on the Excel Center when Bob Nagley brought hockey back to Minnesota. And we did a little bit of work on the Twins ballpark. And with the Twins ballpark, I was on something that was called the Minnesotans for Major League Baseball, which was a Twins-sponsored group that helped figure out how to get the financing that the Twins needed to get the stadium built. That's probably enough.
I'm Nate Snyder. I'm a shareholder at Fafinski, Mark & Johnson. With Jim here, we co-chair our sports entertainment law group, kind of operates under our corporate group. So like Scott, a lot of kind of corporate outside general counsel type work, just most of my practice, probably 75%, has a sports or entertainment leaning to it. Clients ranging from the Big Ten Conference to individual video production companies, kind of influencers, and everything under that umbrella. I leveraged a very poor college football career into creating a position that, and kind of launching a sports entertainment practice group. So I got contacted a little over 2 years ago now to come over to FMJ. The work was kind of too much for apparently one person to handle for Jim, the rest of the group with our M&A practice. And so kind of the idea was to see what we could build with it. And I just kept kind of grinding that into an actual group and job and practice that I wanted to have. Kind of turned that now in the last year into launching an externship, sports entertainment law externship with the law school here at St. Thomas. And so we've had, Hallie was one of the externs, Wyatt, the externs, I don't know if Meredith this year, but we've had 3 externs so far. And so the idea being, instead of having to grind your way to come up with some practical experience to actually get some on the ground work in that space, and to see a lot of the things that we see day to day in connection with serving as outside general counsel to sports organizations. I joked with Professor Granardo last night, looked at the Vikings opening here for an associate general counsel position a few months back, and basically everything on that list of what they're looking for, the duties are what we do every day. So a good opportunity for law students here, so I'll pitch that a little bit, is part of this, to keep applying for that position. It's a lot of fun. Great to work with St. Thomas on that.
Thanks, Nate. Good morning, everyone. I'm Jim Seifert. I'm a partner in Fafinski, Mark & Johnson in Eden Prairie. Been with the firm for about 6 years. Prior to that, I was the Executive Vice President, General Counsel of Ecolab in St. Paul, a Fortune 200 company. And my current practice is I represent the Big Ten Conference in a broad array of commercial matters as well as policy matters, and seemingly the policy matters come up fast and furious because of the current state and ever-shifting state of college athletics. Like Scott, I think a broad commercial background has significant and the most practical applicability to college sports, because if you just remove the subject matter, it's a business. There's a pile of money in the middle of the room, and everyone's trying to figure out how that gets divided, not only currently, but on an ongoing basis. And so there's a lot of complexity of the college sports landscape today, and lawyers naturally are in the middle of it. So, thank you.
Good morning, everyone. My name is Taryn Sharma. I'm a second-year M&A associate at Frederickson and Byron. I graduated from the University of Minnesota Law School in 2022. I'm very jealous of your beautiful building here. I'm an adjunct professor at the U now, as I helped start the Sports and NIL Clinic And through that clinic, had the opportunity to work with student athletes, collectives, teams on a various array of matters. And thank you so much to Marshall and Professor Granardo for having me today.
So for our first question, I kind of want to piggyback off of what they were kind of talking about and see how each of your roles have changed in college sports over the last couple of years following the Alston decision and the use of NIL.
Yeah, so what I'm doing now did not exist before, right? And not because I think that there's this common misconception that Alston somehow was related to NIL. It wasn't. It was education-related benefits, as I'm sure most of you know. But it did allow the floodgates to open. And so when that decision came down, you subsequently had these laws that were going to take effect in the states. And so it was because of that I really got the opportunity to start talking about these issues. So we had a professor at the law school, Professor Bob Stein, who was a legend there, and he was working on a uniform name, image, and likeness policy. And he came and spoke to our Sports Law Association over the lunch hour. We thought it would be really cool to have a class like that, and that's what was the seed from which we grew the Sports and NIL Clinic. And so everything has changed for me. We've had the opportunity now to work with so many people that are in the space, and that would have never happened if the Supreme Court had not decided to take things up, and frankly, if we hadn't gotten such a stirring concurrence from Justice Kavanaugh.
You know, for me, Alston represents the beginning of the earthquake. We can all speculate on how severe the earthquake is. I would peg it at about a 7 because buildings are falling, institutions are falling, and we're in the middle of it. And the whole thing is being refigured. And it was natural that this was going to happen because of the money that was involved. I think of my alma mater, Notre Dame. So Charlie Weiss gets a 8-year, $10 million contract. He has one bad season, gets fired, goes and he's the offensive coordinator for the Kansas City Chiefs. And for those 3 years that he's with the Chiefs, he's getting $10 million every single year. I mean, it just became overwhelming, the disparity between who was receiving the money and who was generating the money. So Alston was a natural way of starting this restructuring is what we're in the middle of. And seemingly the restructuring is being figured out, at least now, year by year. There's no coordinating principle. There's no regulatory agency. It's just we're trying to figure out as we go along. It's like repairing the plane in mid-flight, and you don't know whether the plane is going up or going down. But nevertheless, these interests are being sorted out, and there's reasons for all sides to cooperate. There's benefits to be had. Now, I think what you're going to see is this continuing push toward people that have this, naming the athletes, that have this very narrow window of economic opportunity. Essentially you can go, if you go to 24/7 Sports, you can see who's a 2-star and who's a 5-star. And generally speaking, 3 stars and above has a lawyer and an accountant or financial advisor and potentially an agent who is trying to exploit this very narrow window of opportunity. And they're pushing their economic interests. It's all natural, and there's no sort of guardrails yet on what we're doing here. But the seasons are scheduled, the media rights are there, the money's flowing from the media rights, and they're being distributed, and then the athletes are sort of sitting there trying to figure it out. So we're in the midst of massive change, and I have to believe the government is going to play some major role in this because there's going to be a fundamental question of fairness and balance that has to be played out, particularly for the non-3 to 5-star athletes. I mean, the way you get good is that you practice. Well, how do you practice? You practice against the 1-stars, you practice against the 2-stars. So the reality is there's people, even if they're not at that elite level, that deserve some sort of compensation. Because this notion of the student athlete, particularly at the D1 level, I think is mostly a fiction. If any of you have played D1 athletics or know people, you know, I know on firsthand basis that, and this is not a Big Ten school I'm referring to, but I know on a firsthand basis that people are told, don't go to class, don't be a student. They are employees, they are generating income. And there's a whole human side to this structure which doesn't get talked about. And so these issues are going to come up. They're going to come up through litigation. They're going to come up through articles. They're certainly going to come up through places like St. Thomas that talks about this. But there's a whole ecosystem that is being figured out as we go forward. And I just think lawyers are going to play a very, very important part in that whole, where this thing settles out. So thank you.
And I mean, my position in and of itself didn't exist prior to that case, but a lot of what I'm doing certainly would not have applied. I mean, working with collectives, coming up with agreements for athletes, working with camp businesses and just the businesses that are on the side of coming up with endorsement and the true NIL agreements, not, well, I guess collectives we mentioned as well, but in coming up with the agreements for athletes to really leverage their NIL. And so those are positions that didn't exist, and that type of work didn't exist before this. I mean, the clinic didn't exist before this. So it really is creating opportunities for lawyers, for law students to kind of get active, to learn the law. And met with key stakeholders who have basically said they're relying on journals from law professors and law students in how those things go back to Congress, how they shape their opinions on the matter, how they're trying to craft positions. And so there's a lot that, as Jim mentioned, hasn't happened yet, that it will still continue to fall. And so there's definitely more room here. I can speculate that I think where things are going, kind of the collectives that we see now will probably fall under a university umbrella at some point, just because there's not a, well, as we just saw, I think in the last week, there's not a tax advantage. And I think there's going to be some consequences for some of those groups that are making tax elections, that they're nonprofits now. And so I think it is something for especially law students to kind of keep an eye on. And as Scott will probably tell you, that you guys are the ones that have more time than those of us up here to really become subject matter experts on the law and to really shape that and to advise the partners in law firms, advise the senior associates, and kind of be the ones that really take the lead.
I have a very limited experience with NIL, and it's certainly not on the college side, but it impacts my hockey league, the USHL. And it is a little confusing and a little complicated, because what we have as a league is we have contracts with sponsors and endorsers, and we are meant to do things for them. When you have a player on one of our teams who cuts an NIL deal with another supplier, that creates a few headaches for us. And so we've dealt with that this year, not a lot, but a little bit. And the best example is we're a Bauer league right now. So Bauer's our main sponsor, sticks, skates, equipment. And if we have a player that goes and does an NIL deal and does that deal with CCM, we need to pay attention to that, or Bauer's going to get mad at us. Now, there is a separate existence between the league and the teams. And as a league, and I'm oftentimes involved in enforcing things or dealing with team matters, we try to let the teams do things on their own. So we try to figure out a way to let the two coexist together. But at times, we need to make certain that that player who now is sponsoring CCM doesn't take a lot of pictures with USHL garb on that shows CCM. That's going to give Bauer significant heartburn and cause us all kinds of problems. So what we're in the process of doing is we're developing an NIL policy for all the teams in the league. And it's completely evolving the way this whole NIL area is evolving. And right now, it is called guidance. So it's not truly a policy, and we purposefully did that because we didn't quite know where this was going to go. But that's my limited experience with NIL. It's very practical in how NIL affects certainly the USHL and certainly all of our teams.
There's another point I'd like to make about NIL and how unsettled it is. And this, I think, would be a great topic for a law review articles for anybody interested in it. There is no established form in terms of what NIL agreements look like. And what I'm specifically referring to, and I think where there's a danger zone is that NIL deals, the value of them are based on exposure, right? So if you're a local insurance agency or you're a local restaurant or you're a local car dealer and you want to attach your reputation to a particular player because they either won the game or they're flamboyant or there's something about it that matches up with your business. What if within that agreement it is either explicit or implicitly understood that the money that will flow from an NIL deal is related to playing time? And so what if you've got a $100,000 NIL deal and $20,000 of that is going back to your family? And the player goes to the coach and says, I need to play because I need my NIL deal, so I need some money to send back to my family. I think there are so many issues that are related to this that can infringe on the competitiveness and the integrity of the game, which is another basis for, I think, screaming for regulatory framework. And so this NIL deal, it seems okay, you know, just sort of in the abstract. I've got an image, somebody will pay for it, go after it. But when you start talking about how this might infringe on the competitiveness of the game, then things get really serious. And again, it can be either explicit, right, the written word, or it can be implicit. And this goes from the head coach down to the assistant coaches that recruited the player, that made those promises in the parents' living room. Your son's going to play. There's going to be, you know, at least half the game that your child is going to be in this, which is often the deciding factor as to what school the individual high school athlete chooses. It's playing time, because that's the stepping stone to whatever theoretical next step that athlete wants. And so there is this significant integration in this ecosystem that has to be worked out. And I think this is just one of it. But I think it's a prominent one because it goes to the heart of the integrity of the game.
And you all know this, but we're being governed right now by state laws. And so for me, with my, again, USHL Hockey League, we play in 6 or 7 states. So the laws, depending on the team, are different for us. Not significantly different, but they are different. And at times it makes a difference that they're different. So as we're trying to develop this policy, we're trying to figure out how, from the league standpoint, we deal with all the different intricacies of the state laws, which screams out for something Jim's alluding to, which is more federal legislation or something that's a little bit more uniform.
It goes to say the competitive aspect of it, where you have certain states that are more friendly to whether it's employee rights or kind of those positions where the states are coming in and really upsetting some level of competition, and intentionally so, where there's revenue coming into the states, the schools themselves, if they're more lucrative, they have a better program, they're bringing more revenue out. And so it just ends up being where kind of this mismatch kind of quilt work of state NIL laws really will, if there's not something done, impact the competitive advantages, whether it's from the Power 4 schools on down to from a state level.
I think that the larger point here is that there is a collective action problem, and I don't mean collective like the defined term, but just that there are a lot of moving pieces and we need to have some sort of overarching policy. I think that that's well taken and can be effective if the various stakeholders are actually involved in the decision, not just people that are sitting in a room and they think that they know what's going on the ground. I think we're also governed by some NCAA language, which hasn't been particularly sharp. And I think part of that is because they want to avoid getting sued. One of the big outcomes of Alston is that the NCAA no longer felt like it was invincible. We go from 1984, Board of Regents, you get that small piece of dicta from Justice Stevens, which says that the goal of the NCAA is to preserve amateurism. And they ride that for the next 30 years, and then suddenly we get Alston, which shatters all of that. And that's why I brought up the Kavanaugh concurrence, even though that's not the decision. You go from one small piece, which gives the NCAA all sorts of power, and they really wield that power throughout the 80s, 90s, and 2010s. And you go from that to an entire concurrence, which shatters your entire model and says, basically, if you bring that in here again, we're going to block it again. And so I think that that has completely neutered the NCAA. And so what we have now is this guidance, right? And that word gets used, and it's not really guidance, right? Because there's no true policy there. There are a few small bits that you could take out of there that aren't necessarily going to be enforced. Even the cases that we have seen that have been enforced so far by the NCAA, where that FSU assistant coach or the Miami, the Cavender twins, those are recruiting violations. Those are things that the NCAA has enforced forever. And so I think that they've been hands-off, and that lack of leadership has really left us in the position that we're in today, because their approach has been for ever since Alston, like whether it was now Charlie Baker, begging the federal government for a law. And that's not necessarily an approach that screams leadership. It's just begging for someone to save their place in this entire pie.
Could you guys talk about how you work with student athletes, collectives, and even universities on making informed NIL decisions and what that kind of looks like?
I mean, as far as making informed decisions, it's like with any client, you're trying to figure out what their interests are and how to best protect those. And so, from working on NIL policy and language to a media day event for the Big Ten varies significantly different than it is when I'm working with a camp client or with an individual athlete or influencer and trying to figure out what their goals are and how we're protecting. Scott mentioned the issue of exclusivity. I mean, that comes up all the time. You go over to Target Center a couple weeks ago for the Big Ten tournament, and you'll see that right there, things are blocked. The Jack Links kind of monument, or whatever you want to call it, pop-up out in the Skyway was completely covered off because the Big Ten has an exclusive relationship with the old Trapper beef jerky company. And so it's like, even though Jack Links is set up right next to Target Center, part of the Mayo Square, you can't have those things out. And so those same issues come up with athletes when they're negotiating individual endorsement deals or exclusivity. If you're dealing with a Nike school and you have an athlete that has an Adidas contract, how do you balance those pieces from the advertising side of things to on the court or press conferences, and being mindful of kind of covering those policies of we've worked with schools and drafting their NIL policies and making sure that they're upholding the student athletes are upholding the values of the school, or kind of quote unquote morality clauses in those. And so these are all things of kind of going back to just making sure you're aware of what the individual stakeholder needs are. And that's not unique to sports. That's a corporate attorney, business attorney concept that you just have to figure out and kind of work through with clients that have particularly strong opinions on their intellectual property, and making sure there's protections in those contracts, that someone's not just going out saying they're the official whatever provider of a school. If that's not the case, if there's a one-off that they're sponsoring, I mean, we sponsored this symposium. We are not the official law firm of St. Thomas Law School. I can assure you of that. So, I mean, these are things that just trying to figure out when you're working with any client, but particularly the sports side, that there's just unique pieces now, especially when athletes have their own individual goals and needs in mind. And so it's trying to make sure that there's not the footfall, so you're not tripping up something where the athlete is having to, mention, pay back money if they violate an agreement, that all of a sudden they've sent that money off to their family, and now all of a sudden the sponsor comes back and says, well, actually, you breached this by not doing X, Y, and Z, and then they're calling someone or they're on the hook. I know a lot of these contracts are having confidentiality provisions or arbitration provisions as well, and so these things aren't hitting the public spotlight, but I mean, Wyatt worked on a contract for me not too long ago, and we had a discussion on the attorney's fees provision in that contract and whether or not that was something that should be fee shifting or what the bargaining power is in that. And so it's just trying to figure out the unique needs, just like any other client.
Yeah, I mean, I think after Alston, the conferences, and I'm speaking, based on my experience with the Big Ten, they really did shift in terms of wanting to do right by the athletes. There was immediate discussion about how this should be organized, how do you get reliable information to the athletes, how to coach the athletes, how to deal with money, how to open up a bank account, how to invest the money, how to get your own YouTube channel, all of this. And so there's been this very cooperative spirit, I think, between the conference and the athletes. Some of the specific policy issues that come up have to do with game film and then use of their copyrighted logos. So the game film is a copyrighted piece of intellectual property, and then the logo is a federally registered trademark. So those are solid pieces of intellectual property that have to be managed by the school. And so I don't think this is settled yet, whether each athlete can have 30 seconds of game film or 90 seconds, or how often they can use the trademark. But we've worked on some guidelines in terms of limited licenses for those items. And that continues to be an ongoing debate, because obviously if you've got your own channel, you've got your own other social media platform, this is where your value is. Look at this play, look at what I did, look at my point totals for the season, highlight reels, all of this is sort of up in the air. But from my standpoint, what I've seen the Big Ten do, and certainly its member schools, has been very cooperative and very liberal in terms of allowing access to that intellectual property.
I'm not a doctor, but I think of it like DNA, like a double helix, and they're intertwined. And so it's kind of like two paths, right? The first part of it is the rules of the game. So my students are here, and they're really good at reviewing contracts, and we've worked together on that. That is like the baseline, right? We're making sure that there are no terms in there that are explicitly prevented from being compliant. But the other part is understanding how to play the game. So leverage. If you're a mid-level, fifth-year kind of student athlete, and a marketing agency is contacting you, maybe you don't have as much leverage as, a five-star, one-and-done type that they're trying to get back for a second year. And so understanding that is something that I think I've been learning alongside my students, especially from our other adjunct, Chris Pham, who couldn't be here. But that comes with experience, and so that's been a big part of it as well.
I have one limited experience, again, on the college level with the collective. And it's an evolving situation right now, but the collective is having problems with one of its athletes. And the athlete has gone to the press and complained about the collective, and this is a major college program, and the collective itself is doing some significant damage control right now, and they have hired us to try to help them figure it out, and we have some PR help involved, and then we have obviously us involved trying to figure out where this is going to go. And it just actually developed yesterday, and it's hard to know where it's going to go, but the collective is very concerned for its reputation and also the current athletes it has based on what this other athlete is talking about. And this athlete is a significant football player, and he is leaving where he is and going to another program. But along the way, he's pulling this collective along with him, but in a really negative way. So it's kind of the other side of what can happen here in what we're talking about, but more on not the college institution side, but the collective is its own institution. It's like a three-legged stool going on, I think.
Yeah.
And it's complicated.
And I think you could speak to that, right? How important your reputation is in this area, right? Because while it's like all above board, so much of this is word of mouth and trust. And so if you lose that trust from other student athletes, you're going to have a hard time recruiting and retaining.
Next, I want to switch over into the professional sports landscape a little bit. And I was wondering if you could talk about what working as outside counsel looks like in the professional sports industry, how it might be different or similar than college sports, and kind of what you guys are seeing in that area.
So I don't know how it's different from working in college sports because I just really don't have that experience. But I can tell you that in my experience with some of the professional teams here in Minneapolis, St. Paul, oftentimes we get brought in to do something that the inside lawyers don't have some specific expertise in. Might be an antitrust matter, it might be a litigation matter, it might be some kind of acquisition or some kind of specialized contract. That's typically where we're getting brought in. All the teams have inside counsel. They are in effect my boss, and they call me when they need help. And then I need to, and this is very practical, I need to make certain that I understand that they are my boss, because I also know the top level business executives of all the teams, and then they tend to want to call me and talk to me about things too. And I've been very, very careful about telling them, that's great, I'd love to help you, but let's call so-and-so and make sure that they're okay with this, because they're the ones that are given the workout. That's a really, really important thing to remember. And I remember that because I once made a mistake and it backfired on me big time. And I was very naive about it, and I was a very young lawyer, but I learned that lesson. Do lots of licensing for the teams, do lots of suite license agreements, product license agreements. Just a plain general counsel, stuff comes up. If there's a player issue and it's not a union issue, maybe the player has done something and the team is trying to do some damage control, and we're helping out with that in certain ways. I can think of a number of Timberwolf examples over the years that I can't be specific about, but we got brought in to help with a player issue that developed. A lot of investor work as well. An investor is going to invest in the Wild or the Timberwolves. We'll get brought in to work on that. We'll certainly look at it from a tax perspective, a dilution perspective for the majority owners, but we'll do that kind of deal. That's typically something that an inside counsel doesn't do. Done a lot of arena and operating agreements. When I did a lot of work with the Timberwolves, we were always tweaking the three-legged stool for the Target Center with the MCDA, with an operator, and with the team that had the use agreement. And there were always things to deal with there. A lot of it had to do with availability, and the NBA had to have the availability first, but every once in a while that got screwed up and we had to deal with that. Employment matters come up all the time, lots of team personnel. There might be employment issues. We often get called to deal with those kinds of things.
Yes, my experience has been similar in the employment side of kind of working on the executive employment agreements for kind of the VP levels of sports organizations. And so kind of figuring out those moves. Also done work in licensing of facilities, not directly in the professional sense, but in kind of a Target Center license for an event or Madison Square Garden, kind of those type facilities where there's a lot of moving pieces in them, availability being one of them, and then also work on the investor side of kind of minority interest and kind of coming into new ownership groups or kind of determining what limited negotiating power there might be in terms of making an investment into a professional sports franchise. And those often are very limited, and you, at least from the minority investor standpoint, you just kind of come in with both looking at really what are the main issues on this, because you're not only beholden to the majority group, but also the league bylaws and what their restrictions look like.
I mean, for me, the only real aspect I can speak to with some experience as between college and professional is the significance of the governmental partnership with the professional teams versus the college team. I'm a former state legislator, and when I was in the Minnesota legislature, simultaneously, the Twins were looking for money as well as the Vikings were looking for money. And I remember that whole episode clearly. I was on the Commerce Committee, and so it had to come through that committee. And you know, I was always torn in terms of whether to support it or not. Certainly, you know, I'm a lifelong Minnesotan, and so sports played a role with my upbringing. But here you have these stunningly wealthy owners who are in essence asking for general fund money. And, you know, there's an opportunity cost to this. You can spend it on a stadium, or you could spend it on education. You could spend it on crime prevention. You could spend it on human services. You could spend it on nursing homes. You can spend it on parks and beautification. You can spend it on small town sewer systems. And here, this stunning amount of money, you know, gets spent on stadiums. And this odd dynamic of, you know, over-the-top, ultra-wealthy people saying, give us what we want or we're going to leave. I've always been uncomfortable with that dynamic, but that is the big difference. And I would say, by and large, the leverage sits with the owners and the professional leagues, and that is a big difference. But, you know, each city, each state has to sort this out. And, you know, one of the big issues is that, particularly with the NFL, has done such an incredible job of marrying the identity of the particular geography with the citizenry. Mm-hmm. And when you're talking about, you know, ripping that identity away, or simply coughing up another $750 million for a stadium, you know, this odd human emotion takes over. And I just raise that as just fundamentally different from the college world. So I'll stop there.
Going back to college sports just a little bit, I was wondering if you guys had any thoughts on how your roles might be impacted in the next couple of years, especially after the Dartmouth decision.
Yeah, I think unionization will just be one more thing to think about, but I think that if I were the NCAA or even the conferences, that this would be something that I would welcome, because a lot of the things that bother the fans about college sports today can be addressed through collective bargaining. And so it would definitely change a lot. There would be more things to take into account when you're considering the rules of the game. But yeah, I think that there's a bunch of different sort of tributaries that are leading into this larger river that's going to make change within this field. And so I think about unionization, I think about employment, I think about how the House and the Johnson case might affect the NCAA and the structures that we currently think of as making up college sports. I think that we're bound to have a ton more change here in the next few years. And, you know, I grew up with college sports being fairly static, right? The teams that I would root for, they would return their players every year. And I think that that is irksome for fans who are by and large rooting for laundry, but want to have that laundry worn by the same people over and over and over. And that's just not the case right now. And there has to be something to freedom of movement. But I think that people are looking for more consistency. And I think that collective bargaining is one route to get to that consistency.
I'll jump in. I'm going to piggyback on the fan engagement. I think one of the things that can be really problematic in this freedom of movement is the allegiance that fans have to athletes, but also that the community has to an athlete after they graduate, where an athlete may see this $50,000, $100,000, $250,000 payment to transfer as a fifth-year senior or earlier. What they're not particularly thinking of, or maybe aren't thinking of, is what happens after you graduate. If you're a fifth-year senior, you're probably not going to the NBA. You may not last long in the NFL, and all of a sudden you've just alienated a fan base in your community that probably are going to provide jobs that if you wanted to stick around Norman, Oklahoma, or wherever it might be, that you're probably not getting a job at the insurance agency there if all of a sudden you went from OU and said, you know what, I'm going to go to Texas. And so all of a sudden you're just kind of limiting that long-term earning potential by leaving a school that, sure, maybe a quick dollar to leave, but all of a sudden you don't have a home moving forward, where, I mean, I think to go with, you're rooting for laundry, but it's also, I mean, people in the community. I grew up in Fargo, North Dakota, which has a huge NDSU following. It's like you still see players from years past on broadcast for NDSU, on kind of whatever it might be, affiliated with the media there. I know this past year, so Grant Nelson was a basketball player at NDSU from Devils Lake, North Dakota. Probably saw him play in the Final Four for Alabama. All during Bison football this past year, all you saw was Grant Nelson State Farm commercials. He was not playing for NDSU last fall, and he had a great tournament run, but it's all of a sudden he's a North Dakota kid that now all of a sudden if he comes back to Fargo, I know there's plenty of draft talk for him, or has been for the last couple of years, but it's kind of those relationships and the dynamic of this that I think are just kind of unintended consequences. And not to say that people shouldn't move, but I think that's where the role of an attorney or close advisors comes in to say, you're looking at this from the immediate standpoint and not kind of a longer term growth of what best puts you in a position to succeed. And so I think that was a digression from the unionization side, but just to go back to Terrence's point, as far as unions go, I think there can also be an issue with, again, be careful what you wish for as far as what that negotiating leverage looks like. That obviously Ohio State's football team has a much higher negotiating leverage than Concordia College, where I went as a Division III. We wouldn't have a program if we're trying to negotiate a union contract. And so, I mean, that scales down through, I think there's a lot of opportunities that may be missed with unionization, and it may end up with reducing the number of athletes that go on from high school to be able to have these opportunities, not only at Division III, but I mean, if you look at Division I, Division II, I mean, college scholarships have provided the most college educations beyond the GI Bill of any kind of free educational system. And so there's these things that, yes, there is this component of fairness and making sure you leverage the true economic value that an athlete brings, but how much of that is tied to that individual athlete, the Cavender twins, versus just an offensive lineman at Texas A&M or wherever it might be. And so I think those are the things that kind of worry me, and an overcorrection in this space is that it ultimately may be a negative impact on the opportunities available to student athletes moving forward.
This is purely a fan perspective, not a sports player's perspective. Pro sports are pro sports, get the money, that's the way it is. College sports are something different, and we risk ruining college sports if we're not careful. Strictly fans, strictly me. I get it that there needs to be some evening out, and I think to some extent, don't know to what extent, but to some extent, the athletes have been a little abused in terms of what they do for the programs. But where we appear to be going now is changing the whole face of college sports. When you don't even know from year to year who the players are going to be on the floor for the basketball team or the hockey team. And it's making it not as fun for the fan. And then the point about these players needing to be maybe one place to get the benefits after they're done playing, I think it's a really, really good point. And it's certainly happened here in Minneapolis, St. Paul, with all of the Minnesota football players. There are so many alum Minnesota football players that have been established in business in this town by a lot of folks that have helped them. But when you got somebody moving around three times in a college career, they're just not going to get that. No one's really thinking about that right now, but it's going to start showing itself, I think, to some of the athletes.
What do you see with the Ivy League schools all kind of holding steady and saying, we don't need collectives. The value of your education, the connections you're making here are what really is important. And so that's where I wonder with Dartmouth and that where, yeah, you may get a union, but is Dartmouth really the poster child for college basketball? I mean, it's a program that middling also. I mean, they've had runs, but it's ultimately, these aren't kind of there's a rigorous academic requirement at Ivy League schools. And so I think when you're looking at that, yes, probably the Johnson matter of California is much more likely to have parallels to kind of really what unionization can or should be at the Power 5 level. But it just, to me, becomes what is the value of kind of what you're bringing to, and that's where, from a union standpoint, that's what you're negotiating, of kind of what the value is from the union itself to the school, to the employer, to whatever it might be.
Just for me, and something that you said, Scott, I agree that there is a inherent difference between college and professional sports, and that they're students. But for me, it's difficult to square when the coach makes $10 million and the athletic director makes $1 million and all of the coaches are making money, the TV broadcasters are making money. All of this money is flowing through the program, and yet the labor is not benefiting from it. And so for me, it's difficult to square, like, yes, they're getting an education, but we've heard that sometimes they're being told not to actually pursue things that could be helpful to them longer term. You had the UNC academic scandal where they were just, BSing classes. I think that is the challenge of all of this, in that you have these young men and women that are creating this value for everyone else, and then they don't get to enjoy the fruits of that labor. And to me, that is wrong. And so part of what we've seen, and Jim, you mentioned this, is that you've started to make this change, the earthquake. But I agree that we need some sort of guardrails, but the labor needs to be able to participate in what they're creating, to me. And that's fundamentally important. And it was wrong that it hasn't happened to this point, especially once TV contracts became what they did, which ironically happened after Board of Regents, which the NCAA lost. And because the NCAA lost, it actually allowed them to grow in a way that we couldn't have fathomed on the backs of labor which they never truly compensated for their fair market value. And so I think that those people need to be rewarded for what they're putting in, and at the same time, we need some sort of guardrails, and that's the challenge of this entire space.
Last question from me. If you guys could give any advice to someone trying to get in a specialized area of law, such as sports law, what would it be?
I think that there clearly isn't just one way to do this. It's more about figuring out where you might want to be in sports. You're going to have a completely different experience if you go to a law firm. And if you do that, obviously you need to look at a law firm that has a significant sports practice. Not a lot do. If you go to a team, you need to think about this practical fact. Most of the folks that I know that are with teams are probably now, if they've been in the business 20 years, on their fourth or fifth or sixth team. They're moving all around the country. And that's the way a lot of people who are lawyers at teams advance. A little different than being at a law firm. You advance inside your law firm. You don't necessarily do that with a team. You can, but more often than not, you don't. So that's a different experience. Going to a league is a whole nother different experience. I can't speak to that because I've never represented one of the professional leagues, but I know it's like a big, huge business, and I would think you'd need to be very careful where you're going to get kind of pigeonholed, because that definitely happens at the league level. But it's a matter of asking, I think, a lot of questions and trying to figure out where you want to be. And then the one thing I always say to students and young lawyers, be patient. You got a long time. You got a huge, huge career ahead of you. And it doesn't need to all happen right away. You just need to think about it, be thoughtful, and progress. And I would say your generation versus my generation, you're way better at thinking stuff through and figuring things out. So if you give yourself enough time and not try to move too quickly, you'll make great decisions for yourselves.
Yeah, it can be a grind. I mean, it's one of those things where you have to really want to do it and to have a plan and strategize. I mean, I've talked to probably a number of law students in this room with that very thing. I mean, I didn't go right into sports law. It was kind of always on the back end. The kind of thought that this would be a great way to practice, be a lot of fun. So I think kind of there's that misconception coming into law school, like, oh, I really like sports, I'll be an agent. And then I think as you hear from all of us, there's a lot of different ways that you can be involved in sports and sports law beyond just agency or in-house counsel. I know they'll have some of them here presenting later, but there's a lot more to sports law. And so it's one of those things, law should be fun. And so if you're not having fun in whatever tax law, estate planning, family law, whatever it might be, you're probably not in the right area. And so thankfully I'm in a position where I have fun most days. I won't say every day, but most days the profession is fun. It definitely is and can be a grind, but it's just, I think if you can look at it in kind of parts and just kind of set individual goals along the way, that it's not going to be, you're not going to be representing whatever, Anthony Edwards immediately or anything like that. It's kind of the relationships you make along the way, the things you do to kind of set yourself up to be in a position to learn the basic skills of being a good business lawyer, to kind of contract review, understanding trademarks, having a working knowledge of employment law, those things that can kind of leverage you and just being able to identify opportunities and strike at the right time to find that, okay, this is what I want to do, and so this might not be the job that pays me the most money or whatever it might be, but gives you the opportunity to kind of get a platform, do what you want to do, and enjoy the practice.
Yeah, I think the whole area of sports law, broadly defined, it's flush with opportunities. If you go to a website called D1 Ticker, they have all of the current openings in athletic departments around the country, and there's dozens of them. So that's in the college level. I mean, lawyers are needed, virtually everywhere. They're needed at the school level, the conference level, and the professional side, the league level, developmental league level. Bowl entities have their own full-time staff. And the opportunities exist not only in traditional law functions, but also outside of it. Business development leads, human resources, labor, general employment law, all of those areas require legal training and are highly valued members of the organization. I think there's a couple of things you have to think about on a personal level. And that is, the higher you go up, the more visible the organization you're in, you really have to get comfortable with a couple of things. The compensation is going to be okay, but you are sacrificing your personal life. If you are, a lawyer for a professional team, you will get calls all weekend long. There's no way that is a 5-day-a-week, 8 to 5 job. And so it's all about the team. It's all about preserving the image. It's all about dealing with emergencies, and you simply have to be available. And so if you can get past those two things, I think it can be a really rewarding career. Now, the person who I know and has probably been the most successful at this is Kevin Warren, who's currently the president of everything, the business side and the football operation side for the Chicago Bears. He was a D1 athlete for Grand Canyon State, played also basketball for University of Pennsylvania, got out, law degree, MBA, started representing athletes, and was very good at that, made a name for himself. Then went to be the general counsel of the Detroit Lions, then was hired by the St. Louis Rams, then got to know the Wilfs, and then was hired to do the stadium deal, or the purchase deal, then came here for the Minnesota Vikings as general counsel, rose up to be chief operating officer, then was hired as commissioner of the Big Ten for several years, and then was recruited by the owner family of the Bears to be president of the Bears. Now, along that way, Kevin wrote a book called Leaders Eat Last. And if you want to really, really, really see the inside story of how somebody becomes a successful lawyer, successful executive in sports, you read that, and you will see a relentless human being in terms of energy, commitment, and ethics. I would hold Kevin Warren up to be the model for the lawyer/executive, and he wrote a book about it, and if you want to know about it, it's right there. So,
yeah, I have three. Network. That's the first one. You can't be afraid to just tell people what it is that you want to do. When I was in college, I wanted to work in baseball ops, and so I would tell anybody that would listen about that. And some people are like, all right, whatever. But some people are willing to help. And so it was because of that that I was able to get opportunities in baseball. And then that was the baseline for being able to put myself out there as being some sort of authority, which I wasn't on sports law when I decided to go to law school. And so that helped me connect with Chris Pham, who was instrumental in starting this clinic, and now we teach it together. He helped me get my opportunity at Frederickson. So that's a big one. You should always be networking. Stay top of mind. I think that that's really important. People will let you know if you're being annoying. Maybe not directly, but they'll let you know through their actions. So you just keep on them. The second thing is don't be afraid to DIY. Yeah, DIY. Yeah, do it yourself. So For me, when I came to the U, there was basically no sports law program. I was able to work with the other students that were there, and we were able to build something. And then, you bring in great people. I got my friend Carter right here, and he was able to then start a sports law moot court. So, it builds on top of itself. And if you work with good people and you try to build something on your own, people respect that, and you're going to attract more good people, and they're going to do great things on their own. And hopefully you'll be lucky enough like me to be a part of it. And then the third one, I think that we've all talked about the other things that we do that are not sports law. So don't pigeonhole yourself. There are so many skills that go into being good at this, and I'm still trying to get like the day one skills that would help me be good at this. So you're always trying to add more tools to your toolbox. So don't be afraid to take opportunities that are going to give you opportunities for growth, things that are going to challenge you, and that's what is going to give you an opportunity longer term to hopefully break into this space.
Thank you for those answers. I think we have 10 minutes or so if anyone has any questions.
I think it was Mr. Seifert who made a point earlier about the relationship between NIL and playing time, and that was a pretty compelling point. I hadn't thought about that before. What would you suggest for mitigating the challenges that could come with that, because that does get to the integrity of the sports?
Yeah, I mean, I think you're always searching for this balance, this business of the standard of reasonableness. I think for an athletic department to say, look at it, we're not going to go to our broadcast partner or Learfield Sports and they're driving the bus, or Fox Sports, and so you're going to have to talk to them. There's an important partnership to be had to allow the athlete to use their image in an appropriate way through other things, personal appearances and philosophy and all the stuff that creates an image, to have part of their game film as part of that, whether it's still photography, but mostly it's highlights. And so, any athletic department or coach or who's ever driving the policy on NIL for the particular situation, who doesn't allow that, I think is being fundamentally unreasonable.
Thank you for the insight that you've provided. I have a question about gambling, particularly prop betting. Any thoughts on that? Should it be banned? I'd just like to get your insights on the impact of gambling on sports, the integrity of sports, and so forth.
I think we're seeing it right now in the NBA, that level where there's the investigation. Forget Porter. Jonte Porter, but he's being investigated right now for kind of the prop bets. I'm not sure if everyone here is paying attention to that, but where it does impact the integrity of the game. All of a sudden, he comes into a game, there's, a bench player that has the most action on him of any NBA player on those nights, leaves the game early because of injury, illness, whatever it might be, and all of a sudden there's limited, good money coming back, but is it money that's worth jeopardizing an NBA career? He was, I believe, a 5-star recruit out of high school. Played his brother, has a great NBA career, albeit some injuries. But it's one of those things where it does impact things, and Vegas is sharp. They're paying attention to all of these things, and so if it's a bench player at a Division I football program that's saying, oh yeah, they're not going to score a touchdown, maybe that's a little bit easier. But you start looking at basketball and playing time and those things, and it does impact the integrity of the game, and it's something that I would say it's tough to limit that, but I think from an individual athlete standpoint, from maybe it's the limits on wagers that can be placed for prop bets or outright bans on college sports, but I think there does need to be something done in that space, just because we've seen with Tim Donaghy in the NBA, and just those things where they're, once you either allow or don't allow betting, it does impact outcomes or can impact outcomes.
It's a great question, and just to draw yet another integrity contrast, 10 years ago, gambling was, you couldn't get close to it. You couldn't talk to a gambler. You couldn't go into a casino. I'm talking about as an amateur athlete and retaining your amateur status. But now, every seemingly large event has a FanDuel advertisement. I mean, give me a break, And so on the NIL, to get it to a more practical level, should NIL players, be, what if a casino went to them and say, well, we're going to give you $500,000 if we can use your image. Now in Minnesota, there are no casinos that have a sports book. However, St. Croix Casino and just up Osceola, that has a full-blown sports book, and you go 10 miles over the Iowa border, there's a full-blown sports book. And so, those casinos, and they advertise here that they have sports books. Now, what if they came to a U of M athlete and say, okay, here's some dough, and we want you to be on a billboard just across the border? I don't know. I think the problem is that the leagues and the conferences and the schools have gone from this, you can't get close to gambling, to full embracing of it. And so it's a little bit hypocritical in my mind. And then so where do the athletes fall out here? I think it's one of the many, many unresolved questions as to whether athletes can sign NIL deals for either the entity that does sports gambling, or the owner of the entity that does sports gambling, or online gambling. I mean, this is a very significant issue.
For most school policies, though, that's going to be explicitly, they tell you that you can't reach those types of agreements. So at least as it applies to the U, that would be good. But I agree with you, and especially in terms of professional sports, how in bed they are with the gambling companies, like this Shohei Ohtani at bat brought to you by Caesars or whatever. I mean, it's incredibly hypocritical.
You go to, facilities. The United Center in Chicago has a sports book in the arena.
Right.
Cincinnati Reds, ironically.
Reds do, yeah.
Yeah.
Just a quick question. We have these students here from St. Thomas Law are incredibly bright. We do have a varying degree of sports law background. Could you just quickly explain what a collective is?
That's what a collective is really the $1 million question. And there's multi-million-dollar question at this point. So there are collectives that kind of in the true sense that are doing organizing opportunities. Essentially think of it as a marketing agency that are working with their donor bases, finding these opportunities for student athletes to go out and to be at children's hospitals, to do meet and greet events, to kind of glad hand with the boosters at dinners, things like that. But then there are also the collectives that are kind of not paying for play, but paying for play. That are essentially, you are a student athlete at this school, and in turn, you are getting paid, and there's restrictions they can place on kind of the amount of time or kind of your enrollment or location or proximity to the campus and things like that. But it's just
The most frequent one I've seen.
But it's essentially that you are getting paid because you are a member of this team. And so those are kind of if you think of the major collectives out there for the kind of Power 5, Power 4 schools, but kind of you're seeing now from a mid-major level that more defense than offense at this point, that they're being required to form their own collectives to kind of at least spin something off to student athletes, provide these opportunities, because otherwise you're losing the recruiting game. You're losing players to keep St. Thomas close to heart, the University of Virginia, or NDSU losing players to Alabama, things like that, where all of a sudden where there's more opportunity to go to a larger program that has either a more established donor base or a larger collective that can kind of fund, they are being can be used as, well, they can't technically be, maybe they can now, be used as recruiting incentives.
To that end, I think, and maybe unrelated, I just think it's nonsensical that the fans are being built to pay for these salaries. Like, for me, that's an annoying thing about being a fan. And I do give to collectives, but I'm saying that we would all be way better off if that money could just be delivered directly from the school, the institution that's benefiting from the labor.
Do we have time for one more?
Got one question on the professional side, and I think there was some discussion about the public-private partnership.
Right.
So as, I guess the Yankees back in the day made a bunch of money by spinning up their, Yes Network and essentially almost cut off access to the Yankees to, say, the public, the citizens of the Bronx. And so as, we'll just use that same framework that teams are spinning up essentially paywalls behind their content, and many other professional teams may do the same to justify valuations and just the exorbitant amount of money that's popped up into the sport. So just back on the subject of the public-private relationship, can you maybe discuss a little bit more about that, like entity and like what the rights of the public do have, maybe locally and interfacing with their team? Because, some of these partnerships are being evaluated and spun up by professional teams to put the content behind the paywall, essentially potentially alienating those locally. I mean, those relationships regionally and outside might be different, but just, I guess, in closing, can you maybe talk about that a bit more?
I guess I spoke quite a bit about that. Look, it's a negotiation is what it is. There's no model for it. So every time there is, it comes in the form of a bill, and it's generally for the construction of it. Yet there's all this stuff behind the curtain which rarely gets talked about. And the issue is, there's nobody in the legislature that's ever done this. Nobody in the legislature owns a professional team. They don't know the puts and takes of the revenue streams. They don't know what a billboard in left field costs or what the pricing power is. So all that stuff rarely gets discussed. I don't care whether it's parking revenue or you're going through the Polaris gate at US Bank Stadium. All of that has to do with sponsorships. You go right down the line, in terms of who actually can sell food, the whole vendor world, parking's a big deal. TV deals are a big deal, but none of that really gets talked about in detail when you're talking about me, the owner, asking for $100, $200, $500, $1 billion from a state entity, from the taxpayers, to build something that I'm going to benefit from long term. Say that again? That rarely gets discussed. There's just not an equal bargaining position because there's a huge imbalance in terms of knowledge of actually what's going on. Now, some governmental agencies and entities are getting more sophisticated at this, but it's unequal has been my experience. I don't know. I hope that answers the question.
You were asking about what rights the fan has in terms of, yeah. I don't think that's just professional either, Hunter. I think that if you wanted to watch one of Caitlin Clark's last games at home, you had to do it on Peacock. So it's not just professional sports. I think that is the model, but unfortunately, I don't think that the fan has much of a right to consume their content at all, which is a sad reality, but it is the reality. This is, someone else said it, a business. and the business is to make money. And so if NBC tells you, hey, we'll give you billions of dollars and we want to put some select games, which are going to be big games so that we can drive traffic to our app, that's just the reality of the situation.
Well, that businesses.
Nate, I'm sorry, our time is up. I keep getting little head nods. But I just wanted to say a quick thank you to you guys. Really enjoyed listening to you speak. And I think lunch is now, is that correct, or Marshall? Oh, lunch is at 12:20, so we have a little break here. And then, yeah, we'll be back for our question and answer for original panel.
Good afternoon, everybody. We are going to get started with our afternoon lunch panel here, but don't let that deter you from continuing to go up, grab another plate of food or whatever it is that you may want from over there. But we are going to go ahead and get started here. I want to give you a brief reminder as we welcome back our speakers here from this morning. We have Professor Davis, Professor Mitten, Professor Weston, and Professor Champion, I believe in that order here. So thank you to them for willing to do not just one, but two panels here this afternoon. So the first question that we'll get started with, and there will be some microphones that are running around here. I've got all the questions that people wrote down. There will be some microphones as well. So as we're discussing up here, feel free to raise your hand and ask any questions as they pop into your mind. So the first question that we have for each of the panelists up here is, following the panel this morning that they served on, following the panel that we just heard from prior to lunch, and all of their vast expertise in the area of sports law, is there anything in particular that you want to spend 5 to 10 minutes talking about? Anything that hasn't been hit on that you want to address, or anything that has been talked about that you want to further expand on? We can start with you.
Sure. A couple of things for me. One is expanding on the topic of student-athlete well-being. And I appreciate the comments regarding betting this morning, particularly prop betting. But one concern I have ties into student-athlete well-being as well as the integrity of the game, because student-athletes have been harassed by fans because they didn't make as many touchdowns or baskets that would have won a bet for a particular fan. So again, it's consistent with the theme that all these things are happening, and without a whole lot of regard for student-athlete well-being. So that's the one point I want to follow up on. The other is much more in the legal realm. And that is this case, Shannon versus University of Illinois. Fascinating case in which a judge ruled that the student-athlete has a property interest as well as a liberty interest in athletic participation, inconsistent with years of precedent. I don't consider myself a constitutional law scholar, but I think that and I don't think it's going to be appealed because it would probably be moot at this point, right? Because he's moved on. But I think it's some very tenuous grounds. But I think the important point about the case is that as these new relationships develop, because the court's decision hinged in a considerable part on the presence of the student-athlete's NIL rights. And so as these new relationships develop, they can have unintended consequences. And one thought that comes to my mind is if universities become more intimately involved in paying students for their NILs or facilitating that, will that strengthen any type of a liberty interest claim that a student athlete might have with respect to their participation rights? So, I mean, I think it's rather tenuous, but again, I think someone on the last panel mentioned sort of unintended consequences. So there are oftentimes unintended consequences of changes and developments that maybe it's been thought through, maybe it hasn't been thought through. So even though I think fundamentally that's probably I really question the court's decision in that case, but as relationships change and develop, perhaps there would be a stronger ground pursuant to which an athlete might be able to assert some type of a property or liberty interest giving rise to certain due process rights.
Now, there's nothing on the unsettled out there, so I have nothing to say. No, I'm just kidding. I guess what I would say, and this is from my perspective, having served on a major NCAA committee, which is committee known as Competitive Safeguards and Medical Aspects of Sport. It's been 20 years since I've been on it, but I was on it for 6 years, chaired it for 3 years. And there were two prongs to that. One was, the health and safety piece where you would monitor injury rates in conjunction with the Rules Committee, make changes. And a lot of the other issues, it was at least 100 hours a year of volunteer service. And then the other part was we did all the doping appeals. When athletes would test positive, I did 100 plus of those over 6 years. And there is a lot of emphasis on health and safety. And I was amazed at how much we discussed and how much I learned from people on some of the things we've talked about today. So that, $1 billion a year that the association gets from the basketball contracts, it's remarkable how much of that money goes to providing student athlete services. So they've got roughly 450, maybe 500 people there. A very small number are really involved with the rules enforcement side. The other thing that I think is important is the idea of who is the NCAA? Well, it's a membership association. It's 1,100 member schools across 3 divisions, federated structure, 100 plus conferences. No one in the national office, no NCAA employee makes any of the rules. It's all a product of the member schools. That's really critically important because you hear the media say, oh, why isn't the NCAA doing anything about it? It should be directed to why aren't its member schools? So not even President Charlie Baker, he doesn't have best interest power like the commissioners of the Major League Professional Sports have, which is a huge difference. And that's, a contract right. The schools haven't given it to him. And I've had the, pleasure and great privilege of co-teaching pro sports law with former Major League Baseball Commissioner Bud Selig for 16 years. And that's a very powerful thing. And, he would talk about when he chose to use it or not. But that is really a key distinction to keep this in mind. The third thing would be, wow, why are these coaches making millions and millions and the student athletes been limited to the educational benefits, full value of that now today? It's because of another antitrust case appropriately titled Law versus NCAA, which was a successful antitrust challenge to the efforts to limit the salaries of the 4th basketball coach at the Division I level and others 20 years ago. So that's why you can't really limit it, although you could if the schools banded together and put a salary cap either individually or in the aggregate, you could do it, but you would have to prove it furthers probably competitive balance, and that's the less restrictive means of doing it. So that's the other side of where we're at today on things.
Thank you. I really appreciated the comments of the last panel as well, and I just have some stars on notes that I took. And one was the cognitive dissonance of why the coaches and universities have these huge contracts and deals. And one of the speakers says that labor needs to be able to participate in this whole process. They are critical to that. So understanding the concern that is legitimate in terms of the players' participation, even with the employee issue, even though as I presented it, it was presented as this isn't a one-size-fits-all. It can't for many schools. I don't know if you saw what Coach Nick Saban said. He's out of this. So in terms of roster management with the transfer portal, this is the perfect storm going on. And the collective, the last panel said fans shouldn't have to pay for this. And the fiction that these are actual endorsement deals when it's de facto, it's a recruiting. And so now we don't have control over what's happening in recruiting because could you do some appearances? Could you post a few things on Instagram? So we're really making a fiction of what is NIL when the entire team is getting Ram pickup trucks. But just if you're an athlete, you have to have a schedule. You have to have structure and time and accountability. I need to know who's going to be at the game on X day, and so if we just have it optional to go to practice or to class, In terms of having a roster, that's a tough one as well. So a lot of these issues, I don't know if you saw the last episode, I won't spoil it for you, of Curb Your Enthusiasm, but the word that came to me was catawampus. Like, he was, so you have to watch it, but it's like in disarray, it's mayhem, a hot mess. But just since I have the mic, a couple of issues that we didn't talk about, but there are still very prevalent and important in this, in terms of Title IX, the implications from all of this on Title IX, NIL, and paying, that has yet to be sorted out, but also a number of lawsuits pending and on sexual harassment and assault in college, on college campuses and with respect to athletic teams. And there is a case that is seeking cert before the Supreme Court on whether it's involving the University of Arizona. I forgot the plaintiff's name, but whether the university is responsible for off-campus sexual assaults involving a football player, and they knew that this was going on, and they wanted to keep the football player, happy and a star, especially with what Arizona's facing financially, and so the question of we revere these athletes, and they can do no wrong. But there's other things going on there, and so in terms of turning a blind eye to, we have the star, but are they doing well in their academics and in terms of their conduct and treatment of others? And another couple of issues that are heating up on the transgender issue. So we saw Leah Thomas, who competed in the women's NCAA championships last year, and when she competed in the male category, she was 200-something. After she transitioned, and the NCAA transgender rules at the time said that the student athletes can compete in the category in which they identify, the male-female category. So she identified as a female and was able to win the national championships in her category. And now there's new lawsuits. It's Riley Gaines and of female biological females who are suing, saying that these types of rules on transgender are taking away opportunities. And so there's lawsuits, discrimination lawsuits on Title IX on that topic. And Leah Thomas is also, now the NCAA rule on transgender is, they said we'll align with whatever the International Federation, Sport Federation does. So World Aquatics has said that they've banned transgender females from competing in the female category. And Leah Thomas now is challenging that at the Court of Arbitration for Sport. And there's the Castor Semenya, those cases going up to the European Court of Human Rights. So just thought I'd pass those along as well.
There's a great case out there called Hall v. University of Minnesota. Ever heard of it, anybody? No? I'm almost thinking that you have to. They had a limited property right for a basketball player to continue his eligibility at the University of Minnesota. It was a big, big deal, and so it was really important. He wasn't allowed the opportunity to get into the University Without Walls. Now, the question I asked, what was the easiest college course that you ever had? I think I can beat it. The bait casting at Penn State. I think I can beat almost anything, but they went to the University Without Walls, and, everybody gets to the University out with walls. You find who you are, you do little artwork and stuff like that. They've never turned anybody down, but the Judge Miles Lord said he has, he can continue for 1 year as a college basketball player because he showed a property right that if he was a second-round NBA pick, he would get a guaranteed contract. And so that's like a big, important case that's out there. And once again, they've never turned anybody down from the University Without Walls other than him. As regards Coach Saban, University of Alabama, I'm going to paraphrase from Shakespeare again. He thinks he does protest too much. I'm just saying. I'm going to throw that out there. And we're also talking about how much the money the coaches make. and the kind of attitudes about, these things. Once again, $77 million for a buyout for a coach in college. It's a good deal. They're the ones that are making more money than anybody, actually, and so it's a big deal. Now, Title IX. Title IX, once again, you're kind of interested in how NIL will have an effect on Title IX. Athletic directors are trying to work with Title IX. If you have a big football program, it's very difficult. And so they're always kind of come up, ways to get to gender equity. And what they've always done over and over again, athletic directors are smart and stuff like that. They say, okay, we're going to solve all our problems by having women's bowling. That's it. So if you want to be an athletic director, just come up with that. Women's bowling will solve whatever inequities that we have. And that's, of course, ludicrous, and I don't mean a rapper either. It's just, it's insane. But so that's what's kind of going on with that. And I guess I'll end up with those comments about what we were speaking to earlier on in the antitrust laws that we were talking about, which will, more into the NLL ultimately. It used to be, the athlete who was hindered by the reserve clause or the Roselle rule or something now, but now it's billionaires suing other billionaires. That was never the intent of the antitrust laws. And I'll leave on that note.
Well, thank you all for those comments. We did get a number of questions in following your panel this morning, so I want to talk a little bit longer about the collegiate landscape, and then we'll transition off that topic. So just a couple of questions that came in, particularly around the issues of NIL and if college athletes were to be considered employees. So we'll tackle both of those relatively briefly and then transition through a number of other topics here as well. We've talked about NIL quite a bit, name, image, and likeness. But I don't think we've kind of drilled down into the nuts and bolts of what NIL actually is. And I think that's because there isn't necessarily a strong definition of what it is and what it isn't. So can one of you just take on explaining what NIL is? And if you're a student athlete, how do you go through accepting an NIL deal? Is an NIL package a part of the head coach's offer when they come into your living room? Are they coming to you with your scholarship and promises of playing time as well as an NIL offer at the same time? Do the universities control NIL money? Are they controlling which programs get more NIL money over others? Can you just kind of break down the landscape of that a little bit for us?
Well, I can answer part of it. So it's really interesting. What is now called NIL, name, image, and likeness, was more commonly known as one's right of publicity, which started out in a sports-related case in the 50s. The Second Circuit said basically that Major League Baseball players have a property right in their persona, to advertise. Their name, identity, likeness can be used to advertise various products or services. Now, how many of you would rather have Michael Jordan's career NBA earnings or what he has gotten from just one endorser, say Nike, over time? Probably the latter, right? Those are true NIL rights deals where a business that's selling goods or services goes to someone and say, hey, can I use your name as a product endorser? Most of what is happening today in college sports, those are not pay for publicity. The ones who are getting paid for publicity are largely female athletes, like we saw Caitlin Clark and State Farm and Subway, and I think some other commercials on that. So it's really interesting, which is a little bit sleight of hand in my mind, because what's called NIL today is not traditionally known as, it really isn't, because I practice, in addition to antitrust law, also did what I call non-technical intellectual property, trademark, copyright. I have an economics background, not hard sciences or whatever. As I understand it, under the current rules, the guideline, no pay for play, a court has not yet invalidated that, although that's almost inevitable that it will happen. So it's not supposed to be, all the coach can offer is full cost of attendance scholarship and any academic in kind or cash bonuses or whatever. Schools aren't really supposed to have much involvement with their collectives, but of course we know that they do. But that's about all I can speak to at this point, so.
Because we're seeing the head coaches going out on behalf of these collectives to raise money, right? As they're playing the transfer portal or trying to recruit high school kids.
Yeah, I mean, I think the coaches are telling the collectives, gee, we really could use this quarterback, and then finding out it's probably going to cost us, X amount. I know Ryan Day at Ohio State said, well, to keep the players we want, to recruit from high school and to transfer thing, about $14 million a year. And I know Gene Smith, the outgoing athletic director, has said, and a lot of these, most of the athletes have agents, which they can have for NIL deals. He said there's some student athletes who say, we don't even want to, we're not coming for an on-campus visit unless we get $5,000 cash to do it. Which Ohio State says, no, you're not going to give you that. But some of them still end up with 6 and a few 7 figures from the collective.
So Professor Mitten, go ahead.
Oh,
yeah.
Well, the NCAA has rules. So the chronology was Alston came out, that Florida and California expedited their NIL NIL rules, laws, and then the NCAA, July 2021 said we're suspending our restrictions on NIL. But then they said, well, we need to have rules on institutional involvement in NIL deals, because the idea is each of us has a right of publicity. You should be able to go out, and if you want to have your own YouTube channel marketing, then each of the students should be able to do that on their own, but the institution wasn't supposed to be involved. Then they didn't envision the collectives coming in and or the boosters. So if they're a booster, they're aligned with the institution and they're bound by the same restrictions and not to be using this as essentially pay for play. The NCAA, there was, the first investigation involved John Ruiz at Miami, and he posted a picture, tweeted a picture of him with the Cavender twins from Fresno State, who have this huge social media following, and saying that they're coming to Miami. So there was they did a negotiated resolution, but where one of the coaches took the fall for that as a violation. And then the NCAA has since suspended their investigations. Their infractions committee doesn't know how to even prosecute their own rules because they're getting sued, and was that the Tennessee case where the court entered a preliminary injunction enjoining the NCAA from enforcing its rules, restricting institutions from being involved. So now the institution still technically can't be involved, but they have education centers. It's now a whole part of the institution on how we can help you market yourself, and it is the inducement to but the collectives, one thing that might deter the collective now is the IRS is looking into their alleged tax exempt status. And when you give money to St. Thomas, Dean Nichols will say thank you, and then it's tax exempt. But when you give to a collective, is that really a charitable purpose when the purpose is for commercial opportunities for athletes?
So the last point on the NIL piece, and then we'll transition to the last topic on the collegiate side, which is if student athletes become employees. What do you think NIL, and briefly for each of you, what do you think NIL will look like in 5 to 10 to 25 years from now?
I think it'll be tempered if first of all, if the collectives can't, because someone's saying, why should the fans pay? So if they lose their tax exempt status, fans are less likely to be giving directly to the collective. I'll give to the school. And then your second point, what
do you think it'll look like in 5, 10 years?
We may see direct payments or revenue sharing. There's lawsuits on wanting a piece of the pie, and California has introduced legislation requiring revenue sharing, so we might see more of that.
So you're saying in that situation, under what California is proposing, the TV contracts are split up amongst the football players, or the student athletes for the colleges that are getting a cut of the pie out of the TV.
I think we're going to see more of that. Tim, do you agree on that?
Possibly. Who knows is really probably the most accurate answer. But I do think that as these new structures emerge and as you get more examples of abusive contracts that athletes are entering into unfair contracts where in exchange for a payment of $350, they promise a certain percentage of their professional earnings in perpetuity to the organization. I think that, and I know it's sometimes we can be very cynical about Congress, but I do think if enough of those instances continue to occur, it might actually spur some type of congressional action on NIL. Because I do think it's needed, in part because of the potential for abuse of student athletes, but also just to provide some structure. So the short answer is, I don't know. The other possible answer is perhaps Congress will step in, because I do think there needs to be some type of a more comprehensive framework for regulating NILs. And again, I come very much from the perspective of protecting student athletes and protecting student athlete well-being. I mean, apart from all the financial issues that arise, I think protecting student athletes, for me, would be enough to really try to support some type of congressional action and legislation on this.
So, Professor Davis, building off of your focus on the protection of student athletes and focusing on now if they were to be considered employees, would student athletes now as employees receive greater protections?
They conceivably could. I mean, if you want to draw a parallel to professional sports, the collective bargaining benefited athletes because collective bargaining allowed for greater protections, everything from more uniform and higher minimum salaries, as well as health-related benefits and pension benefits. So if you want to draw a parallel to professional sports, I think collective bargaining could be beneficial to student athletes. It could also protect them from abuse. Again, it's all about the leverage and who would be the bargaining units. You know, earlier today it was mentioned that, and I can't remember exactly, but about the question of whether or not, okay, it just came back to me, the question of whether or not the NCAA can be deemed to be an employer. I really question that. I mean, because of the lack of some basic things, contractual privity, all right? And maybe it could be, but I don't know. I think collective bargaining could overall be beneficial, but I would have questions about the bargaining units, who would represent, the institutions, all of those types of questions emerge, and I'm simply not sure, but I think it could overall be beneficial.
Well, on the other hand, student athletes could be a lot worse off, which is, just went before Congress last month. And I started with the NCAA Constitution. If you look at the new Constitution, which was enacted, went into effect August of 2022, there's really significant protections for student athletes, particularly at the Division I level. So if there's unionization and collective bargaining, let's compare now. Intercollegiate athletes get to choose wherever they want to go to college, right? They can transfer as often as they want as a matter of right. They can pretty much do unrestricted NIL rights deals. All of those things fall within mandatory subjects of collective bargaining, and there could be restrictions. So, for example, if you look in our casebook, we have the NBA uniform player contract. One of the provisions says all NBA players' endorsement deals are subject to approval of both the club and the league and shall not be unreasonably withheld. That's fairly common. Like it's like the league, then the club, then the athlete. So those things come into play. The other thing is once you're characterized as an employee, then when you appear in a broadcast sporting event that's protected by federal copyright law, that's considered a work for hire. Federal copyright law preempts the athlete's state NIL or right of publicity rights. And then again, we're back to tax law. It's kind of the idea, if I were the IRS, I would say every single thing that an intercollegiate athlete gets that is part of the benefit of the bargain you're not getting it, the athletic scholarship, unless you're an athlete, then it's all taxable. So how'd you like to be a Northwestern University football player? That's probably worth $100,000, that scholarship. Guess what? That tax-free benefit is now taxable. And it's not only the IRS that wants a cut, but why wouldn't the state or local governments? Philadelphia, for example, has been notorious. If you play for the Packers, one of your games against the Eagles, their view is up 1/17 of that multi-million-dollar contract subject to tax. So there's a lot of implications that really have to be considered. And I think what's important is focus on who is advocating for various, quote, rights for student athletes. It's usually those people, if you look behind them, there's an economic interest that they have themselves, which may well be different from the student athletes.
Any other comments regarding student athletes
A
becoming
couple that may or may not have any relevancy whatsoever. My sister started that program. What program is that? In Philadelphia.
Oh, yeah.
The 117.
She's the one.
And in Philadelphia.
She's not a fan of agents and professional.
She never got anything out of it, but that's all right. And I have to respond. You mentioned Michael Jordan. So I just want to say one thing about him. We have a lot in common. We both did make our 9th grade basketball team. And also, most unusual thing, he went from 6 million to 38 by playing baseball badly for a year and a half because he was able to sign with his old team without the salary cap whatsoever. I also want to talk a little bit about the California Fair Pay to Play Act, which kind of, it really began everything. And I think California was trying to do the right thing, but then there were other states that may not have been so noble. I'm just saying. So they were going to give the NCAA a large amount of time to respond to it. And the other states, I'm not saying it was Texas and Florida and Alabama, but they're saying, okay, we're going to get there early. We're going to be in effect before you. And that kind of changed things around also, big time. So once again, but I don't think it hurt California out in any way whatsoever. Let's see, Texas A&M, $77 million. And every time you talk about Texas A&M, you have to talk about Johnny Manziel. Johnny football. He did so much for that program. And the NCAA was all over him because he got $200 to buy beer for his friends. Beer again, we're talking about. And, so he did that. And they were all over him because he has a signed autograph helmet. Now, A&M was auctioning them for like $10,000 a pop. He wasn't getting any money whatsoever. So his lawyer, who I actually know a little bit, he said, okay, we did a really terrible thing. We want to be punished badly. What we're going to do is Johnny Manziel is not going to play at all for the football game in Alabama. And whoa, no, we didn't mean that. We didn't mean that. Why don't you take him out for the first half against Rice? And I don't mean an insult to your college football career whatsoever. One other comment about the NIL is that, the rich get rich, the poor get children and tax liens and stuff like that. But it's just like professional sports. The Yankees will be up there every year. The Dodgers will be up there every year. I have no problem with that. It makes it interesting. You have someone to hate, right? Isn't life better when you have someone to hate? It makes it more, amusing and interesting. So the case of House v. NCAA, I think that we should talk about that later on. That may make a monetary stream that, what's going to happen with that? With House? Anybody, any idea? Or what are they asking for, like $4 billion or something like that? So.
There's a 4-year statute of limitations under the Sherman Act. So they're basically saying is once the association indicated that, student athletes can earn money from their NIL rights, that like any other college student, so trying to go back 4 years and say, those who didn't, and it's mandatory treble damages, and it's a fee shifting statute for prevailing plaintiffs. So, and that money that goes into the association, like 97% gets pushed out to the schools. Most schools' athletic programs don't generate positive revenues. It's mainly just Division I FBS football and largely the autonomy conference schools, and then some men's basketball, women's basketball. So that will have some, less money going out to schools. There's I think 22,000 intercollegiate athletic teams that NCAA colleges and universities sponsor. The vast majority probably less than a couple hundred pay for themselves. So look what's going to happen. And, I agree with Professor Davis, and it's like the focus should be on what's in the best interest of the student athletes. Make sure they get an education, health and safety protected. But if we go to maybe, 200,000 intercollegiate athletes at the NCAA level, I don't think that's a good thing.
Professor Weston, any final comments on student athletes as employees or NIL?
No, I'll look forward to what others have to say.
Of course. So let's transition now. A few questions came in following the panel this morning as it relates to antitrust and the specific issue there. There's a couple of questions that came in, and I'm going to try to put them together a little bit. One revolving around the PGA Tour, Live Golf, foreign ownership of sports teams, sports washing, I guess is, I think, the term that's been used recently. The UFC, do any of you want to try to tackle the topic of the legal issues that are presented, maybe in particular in the golf situation between the PGA and Live or the UFC, and how other professional sports leagues could be impacted by decisions that could be rendered in those cases?
Who wants to take that on?
Nobody seems willing to.
Well, I'll just talk real
I
briefly.
will say it was directed to Professor Mitten, so.
Well, on the antitrust, and I'll leave the other things. So, it's a horizontal merger between the PGA Tour and Live, and those are the things that get the most close antitrust scrutiny, where you've got competitors, that offer competing major league professional golf tours. So you're starting to see more government involvement in antitrust. For years, you rarely saw it. So those cases we talked about this morning, which were Sherman Act Section 1 cases, it was the Ohio Attorney General and others challenged the rule on transfer rule, the there's so many things trying to keep them all straight. Can't use NIL for recruiting. That was the lead group there was the Tennessee Attorney General's office. I think there's going to be very, very close scrutiny by either the Department of Justice Antitrust Division and or the Federal Trade Commission. They kind of divide up enforcement over that. And I was supposed to speak at a ABA antitrust section meeting in DC a couple days ago, but couldn't make it. But I read something about the commentary was there was a Department of Justice Antitrust Division official sitting front row, just listening to the discussion of a couple panels on the application of professional sports, application of antitrust to professional sports, taking notes, not saying anything, but it's almost a certainty that that will be challenged. So for example, the American Football Conference in the NFC, they used to be separate leagues. And they had to get special congressional legislation in the 60s for them to merge. So I think there's some real significant antitrust issues that'll be raised.
And on the Live Golf and the PIF, the Saudi Investment Fund, wasn't this all settled last June? I remember turning on the TV and I got sucked into the Golf Channel for an entire day going, what the heck? Because when you had the players leave the PGA, it was the players suing the PGA saying you can't restrict us. That was the antitrust. And then all of a sudden, the PIF investment fund, the Saudi investment fund became the party. And I remember gas prices were high. Biden goes to the Middle East and the Department of Justice is telling the PGA, you shouldn't, back down from going up against PIF. And now Jay Moynihan the commissioner goes on mental health leave. They can't afford to compete in the attorney's fees race with this. There's a settlement, and now the Department of Justice is back scrutinizing this. Meanwhile, the term sports washing, it's been around, but it really came to prominence in 2022 when this was breaking, because countries with documented human rights violations and what happened with the reporter, and then sanitizing their human rights violations by getting involved in sports, which are hip, right? That's why you have commercial sponsors wanting to sponsor sporting events is because it raises their cachet of why we all like sports. And the Saudi Arabia, the Olympics, they weren't allowed to compete in the Olympics because there was a restriction on women competing in sports. So then they got one from Pepperdine, Sarah Tarr, to compete in the Olympics. They had to have field a women's team, so they allow a few women to participate. But now also getting involved in ownership, and I know we want to talk a little bit about the ownership aspect as well. But so, should we allow foreign investment of NFL teams or NBA teams so that we have foreign ownership of Premier League teams? So I think Man City, and this has been going on in Europe. The Northwest, the national women's soccer team just passed a rule saying they wouldn't allow foreign ownership in their league, but I haven't thought fully through the legal implications of restricting based on xenophobia or just foreign ownership. But when you think about that, if these countries with big resources come and buy the Timberwolves or other teams, what does that do to the control of the sport and to the fan base?
And gas prices are even higher.
Yeah, no kidding.
Well, with the LIV golf, it was like the biggest topic out there. And anytime you have a big topic in golf, that's a big topic. Because, so that was amazingly interesting. And then all of a sudden, they were about to do a contract. And then all of a sudden, billions of dollars came from the U.S. Patriotic money. Patriotic money came in. And so I think that deal is gone right now, right? Yeah, you do. How does anybody know, right? It looks like it is because, the patriotic Americans, and, we talked about the civil rights violations with Saudi Arabia. Can the United States really, can we, I don't know. But it looks like that lib deal is gone, right? I mean, it seems that way. You don't know. No one knows.
But there's another sport that they're looking to buy into.
They always do.
Yeah, so it could be, if it's not golf, there could be other sports.
Yeah.
Let's talk gambling.
Okay.
Now, if we can. So that came up briefly on the panel before this one. So for reference, gambling is not permitted in the state of Minnesota right now. I'm actually in a law of lobbying class, and I've been following the effort in both the House and the Senate during this current legislative session in Minnesota to try to legalize it. So it's been a fascinating semester following that as it's been going through both the House and the Senate. But Professor Champion, I'll start with you because you shared with me that you wrote a book on gambling.
Yes.
And so why don't you explain your perspective on sports gambling, current framework that exists, whether it's at the federal level, how different states are approaching the legalization of gambling.
Okay.
And then we'll open it up to the rest of the panel for comments.
I wrote Gaming Law in a nutshell, available on Amazon for a small price. I will give the autographs without any problem whatsoever. That would be absolutely free. But
I'll be your agent.
And I think I now get a cut of all book sales.
there you go. And once again, the only reason I wrote that book is because I have a great name, Champion on Gaming Law. So it's just, the sports book have just changed everything. I'm gonna, how could the Oakland Raiders move to Las Vegas and get a $1 billion stadium for $1? Something's going on. We don't know what's going on. I'm not going to say what's going on, but it's really, really opened up. I'm writing the third edition on Gaming Law in a nutshell, and about fifth is going to be on the sports books. There are federal laws that control, most of them are incoherent. They use the Wire Act, which was 1963, I think. It was for horse betting and stuff like that, where they would get the wire and find out the results a little bit earlier. That's not applicable anymore. So with the Murphy v. NCAA kind of changed everything around. They said PASPA was no longer controlling, so the states were pretty much open to do to sports betting. PASPA, I made an article that said PASPA's got a brand new bag. It wasn't a good article, but I thought the title was really clever. And so that's out. That's just gone. And so basically, we're going back to the the states' rights. They have like 4 or 5 federal laws, all of them incoherent. I mean, they're just like, let's try to make the most incoherent law in the world because we really don't want to get involved in this, but we're going to make it incoherent. And they've done a really good job. But so the states are involved, and I have never been categorized as a Federalist ever in my life. You got to believe me on that one. But I'm thinking I have a lot in common with them because I think that I should have the right to play blackjack and smoke pot. I should end it right there. But it's all about the states' rights. And so that's what's going there now. And they're looking at it. And some states, like, for example, in Nevada, what don't they offer? I don't want to think about it. But Utah doesn't offer anything. You can hike and breathe really good, the fresh air. And that's about, that's about it. So there you go. So it's an ongoing thing. The leagues used to, abhor to be, connected with that whatsoever. And now, of course, there's gambling all over the place, the advertisements all over. They're never going to back off from that because that's too much money. They're not going to do it. I guarantee it. Daily fantasy sports, which is not viewed as the gambling, even though it is. I've always said that, the law students and lawyers should get involved in daily fantasy sports because it's basically analyzing the contract situations and stuff like that. And your competition, who's your competition? Drunken frat brothers. If we can't beat drunken frat brothers, as lawyers or law students, forget about it. So on that, I'll back off.
Wonderful comments.
Well,
thank you very much.
Yeah, exactly.
In defense of the leagues who were against this before they were for it and completely embedded now with the casinos, there is that disclaimer like, do you need help? And dial this 800 number. So, I think they've trying to get, Otani's interpreter needed that 800 help number.
That's something we can.
And the reality is it's going to lead to more gambling addiction, particularly amongst young people. That's just the reality. That's, again, one of those not unexpected consequences. So.
And I could just add one thing. They claim that Adderall, which no one's ever used here, I know that for exams or whatever, I know you never use that, but Adderall apparently helps the addiction process to be a gambler. There you go.
Interesting. Wow.
That's something.
Well, I have nothing to add to that.
No one does.
Collectively, they've covered it up, said it all.
Yeah, and you can't watch sporting events now without, I try to watch tennis and it's FanDuel and DraftKings. California, it was it was a proposition 2 years ago to legalize sports gambling in California. And in California, gambling is in the authority of the tribes on Indian reservations. And then the way it was framed, because and DFS, by having the daily fantasy already out there, as soon as it was legalized, they just jumped right in as major players because it already was gambling. But California, the proposition was saving the homeless act, something, and so how could you be against that? That's how they framed the legislation to legalize gambling, saving the homeless act, and people are like, that's stupid. But on the one hand, because I've thought about this, and well, if we legalize, it's happening anyway, and it's always been happening. And so if you legalize it, tax it, like marijuana, regulate it, but now it's become expensive. Like there's issues with even that topic. But what are the reasons in favor of it? So it's one thing to make it legal, transparent, taxable. Is it proper for the leagues to be totally in on this? And on the one hand, the gambling industry is completely freeloading, ambush marketing off of the sports industry. They're doing nothing to develop the players. They're not, they're worse than the NCAA. So they have no investment other than freeloading off what happens in the sports industry. And so the leagues are like, we might as well get involved and get a piece of it.
Just one real quick comment. I think gambling, unfortunately, is what's propping up college sports right now. I was really surprised to see, you think of Abbott, Ohio State football fan and go back to a lot of games, and if I'm not there, I'm going to be watching them on TV. A huge, 4 million on a typical game, that's like the gold standard. Hardly any games reach that. And what's interesting is there's pretty well-established precedent that says athlete statistics are not part of their NIL or right of publicity rights. So I think when you really start cutting through it and considering how many other, all the athletes stand on the backs of others in things, even with Johnny Manziel, Texas A&M, having been a former faculty member there before the merger with the law school got overturned, they sold out all their games for years before that. So it's really, if you look at it, it's not so much a particular athlete at the college level is driving the needle. It's, what's happened, they've been playing college football since the 1800s. So when you really try to focus on what the economic value is, I'm not sure it's quite as high as some would suggest. It's substantial, but maybe a little bit less. It's a different model than professional.
Professor Davis, any last comments on gambling? And I know in your PowerPoint presentation this morning, you spoke a little bit about prop betting and the impact that that has on college athletes in particular. For those who aren't familiar, prop betting would be, if I'm a player playing basketball, for example, there is a line set on how many three-pointers I might make in an individual game. So you'll hear terms like the spread or the line. Those are your more traditional betting terms, I guess, in terms of who's going to win the game and by what point margin. Whereas the prop bet market or the prop betting activity, that's much more focused on individual player performance on a particular area that's set by these sports books.
Yeah, I think it was Mr. Seifert this morning who may have mentioned we're talking about people, we're talking about humans. And prop betting is one of those instances where I think this gets lost, that you're talking about young people who are very vulnerable. Athletes have a significantly high rate of mental issues. People don't realize that, all right, for a variety of sources. So this is just something, another vector that will flow into the mental health issues that athletes will have to deal with and encounter. I mean, I've already I begin to read stories about fans and others harassing student athletes because they didn't make the three-pointers that would allow them the fan to win the bet. So again, another instance of a potential, well, actually more than a potential, a real threat to student-athlete mental health.
We only have a couple of minutes left, and I want to talk now a little bit about advice that you would give to students about breaking into the sports law industry, and in particular, give each of you an opportunity to talk about the various things that you're involved with. Professor Weston, I know we've talked a little bit about the opportunity that you have for students to go out to Switzerland, I believe, with you, and all of you are involved in different initiatives. So if each of you can kind of plug the programs that you're involved with and share any advice that you would have to students, we would greatly appreciate it.
Well, thank you for that invitation. I'm very much an advocate of students getting outside of the classroom, doing what you're doing right now, going to conferences, participating in the competitions. There's a lot of sports law negotiation, arbitration, moot, advocacy competitions. I also like to take my students out into the world. So right after graduation, we get on a plane and we're opening it up to others as well. But I've done this with a CAS arbitrator, Jeff Benz, and because I want to partner with someone who can give you a realistic perspective, and then I do all the work. But so we're going to go to Geneva and go to some the UN, NGOs. There's a lot of different human rights issues going on in sport right now. We're going to go to the World Trade Organization, which is actually named in a lot of these sports equipment trade. So there's so many areas, as they were saying, that you can get involved in sports. And then to Lausanne and the Court of Arbitration for Sport, World Anti-Doping Agency. There are over about 40 international sport federations in Lausanne, so going out and talking to the lawyers and doing the inspections there and then having class simulations as well. Pepperdine has a facility outside Lausanne. Then we're going to take the train to Paris and on the eve of the Olympic Games, get meetings with Olympic-related officials so that what's it like to host a game? What are the security considerations, which are extraordinary? They're trying to take down the bucanistas on the River Seine, the bookstores, because that poses a security threat. I wrote a paper on breakdancing, which is going to be thank you, yes, I did, as a way to bridge the cultural and financial divide in sports, because so many Olympic sports are country club sports, and Paris is having, as they're introducing, I think, skateboarding, surfing, rock climbing, and breaking, and it's going to be on the streets of Paris. So I want to check that out, and I'll do a few moves for you later.
I was once chair.
With Professor Champion, of course.
Okay. I was once chair of the Sports Entertainment Law section of the North Carolina Bar Association. We were always looking for students to get involved. I know currently that committee seeks a blog posts from students. It's about getting your name out there. So because there's so many law students and young lawyers who want to be attorneys, that it's about getting involved. Once you graduate, get involved in one of those committees so that you can perhaps participate by making a presentation at a CLE. It happens. People approach you. You do a good job. Show that you have more than an interest in sports by perhaps writing a law review article, even if, beyond the comment or note that you'll write for this journal. And because many secondary journals will pick up student law review articles, perhaps co-write a law review article with the professor. And there's only one here, so maybe someone else, all right, so he's not overwhelmed. So the other advice I would have really comes from a story that was shared to the students at Wake Forest. There was a lawyer at Nike who shared the following story, and his job was he worked on most of the major endorsement contracts, and Matt knows what I'm talking about. And he shared the following story. When Nike was looking for an intellectual property law expert, they went and found the best intellectual property person that they could. It was a woman who had no interest in sports whatsoever, but she was the best they consider her to be one of the best IP lawyers. So develop an expertise and then develop the networking that will allow you to get the exposure so that people will know you. And I think that's the way. Since I've been at Wake, I would say there have been probably 5 students, and I've been at Wake since 1998. And there have been 5 students who have gone directly from law school into sports, and I consider that high. All right, I really do. But the others have made their way into sports law in a much more indirect fashion.
Yeah, what I would suggest is, getting involved in the Sports Lawyers Association. You can become a member as a student. It's relatively inexpensive. I think it's less than $100 a year. Professor Weston and I are on the board of directors. I've been a member since, I think, 1990. Served as president a couple years ago. And the sports industry is very network-based, and you have to get to know people. So there's an annual conference that we have. It's in mid-May, and just a wide range of topics. There's also a lot more online programming throughout the year and outreach events in various areas. I'm sure there's some here in Minnesota. There's a student writing competition, and it's open to any student at, any law school. It's got to be an article you've written while you were a student. And there's something called Teamworks where you can sign up for that, and there's members only things where there's quite a few postings for internships and job opportunities. It's really kind of a growth area. And to pick up on what Professor Davis says, I delight in telling the students at Marquette, we've got the most comprehensive program. We've actually got, I think now, 16 courses, very little overlap. Everything's readily transferable. There's very little sport-specific law. But I delight in telling the students, I never took a sports law course. I'd love to get the sports law certificate, which you can get if you satisfy 8 requirements. But the best thing is just being a really good lawyer in something. And, networking, and then when your opportunity comes, you'll be well prepared for it.
I could just add, what you should do is leverage your contacts. That's probably the most important thing. And the state bar and the local bars are always, not the local bars, I don't mean the one down the street, the local bar.
Which is where we're headed.
For sure. But they have sports and entertainment groups. Get involved with that. That's all. I mean, it's a lot of fun. Worst you have to do is come to meetings like we have here. Which might be more than you want to bear. But we all have contacts. Most of us did really interesting things in college. Leverage those contacts. You know people.
Yeah, and connect with us on LinkedIn and then see who we're connected with.
Yeah.
And so stay in touch that way. And I just want to say thank you. Your eyes aren't buried in laptops. So I really appreciate that. It's so refreshing. Thank you.
Well, thank you to our speakers, Professor Davis, Professor Mitten, Professor Weston, and Professor Champion. Thank you all so much for your time, not only for serving on one panel, but coming back again after lunch and serving on this one. So thank you all very much.
Thank you.
All right, welcome back, everybody. Again, my name is Marshall Kellner, and I'm the symposium editor here for the Law Journal. And very happy to be moderating this final panel on the state of representing professional sports teams. We have 3 esteemed panelists, and their biographies are in your programs, but I will just introduce them each briefly. First, closest to me, Mary Giesler from the Minnesota Twins. She joined the Twins as its first general counsel on March 24th, 2014. She was promoted to senior vice president and general counsel in 2016. Since joining the Twins, she's led the club's legal efforts for the public-private development of Target Field Station, a unique transit hub with public gathering spaces immediately adjacent to Target Field, and the construction of a new player development academy in the Dominican Republic, which opened in 2017. Prior to joining the Twins organization, Giesler was a longtime partner at the Minneapolis-based law firm of Kaplan, Stranges & Kaplan, where she served a variety of clients in the areas of public-private partnerships, corporate governments, M&A, and securities law matters. And through her work at Kaplan, Stranges & Kaplan, she played a key role in the negotiation and preparation of many agreements that were integral to the approval, design, construction, and opening of Target Field. She received her law degree from William Mitchell College of Law and her BA from Gustavus Adolphus, and is a native of Aiken, Minnesota. Right next to her, we have Renika Carter from the Minnesota Vikings. She's the Senior Director of Legal Affairs. She has traveled around the country speaking on various topics, including sports law, athlete branding and marketing, intellectual property prosecutions, blockchain technology, cryptocurrencies, and smart contracts. She's also published several articles on these topics. Renika attended the University of Virginia School of Law, where she earned her JD. During law school, she served as the editor-in-chief of the Virginia Sports and Entertainment Law Journal. She also attended the University of Florida, where she earned both her master's degree in business management and her BA in sport management with a minor in business administration. And finally, on the far end, we have Ben Dugan, who's the manager of legal affairs with the Minnesota Wild. He previously worked as an intern at the U.S. Coast Guard, Judge Advocate General from January 2021 to May 2021, and also has had some very interesting jobs leading into that, including working at a whiskey distillery and a craft beer company. He also worked as an Italian tutor at Duquesne University and earned his JD from Roger Williams University School of Law and a BA from Duquesne University. Welcome to all of our panelists. So we'll start with this. I think when team counsel comes, students are always excited and they say, wow, how did they get to these positions? And I described it just briefly, but let's just go down the line here first. How did you get to where you are, and what were some key steps along the way?
Is this on?
It is.
Oh, Okay. Well, first of all, thanks for having us. And I just have to remark, it is so lovely to look out into a sea of people dressed like lawyers. Wow. So kudos to you. That is a lost art. So, the short story, a little bit of luck and a lot, emphasize lot, of hard work is how I ended up in the chair that I hold today. Make no mistake, this is not something that you engage in casually. You're either all in or you're out. And someone on the prior panel mentioned the importance of relationships, and I think that is critically important. The ownership of the twins did not know me. How did they get to know me? How was I even considered for this role? And as Marshall mentioned, by happenstance, I got involved. For those of you who are from Minnesota, you may know that at one point in time, the Minnesota Twins were for sale. On a similar path, they were a potential target for contraction through Major League Baseball. And at the same time, they were at the Minnesota legislature looking for public support to build a new ballpark. And I was at the legislature the night that, in fact, legislation was passed that facilitated the building of Target Field. I mean, there's a picture of me and Dave St. Peter just like, oh my God, we can't believe it. So literally, we moved one day from figuring out the team was no longer for sale and how to build a ballpark. And so from 2006 until opening day in 2010, my mission was, in fact, to figure out and to assist ownership in how to build a ballpark. So that, it opened in 2010. The work related to that did not conclude, after the first game. It continued. And in 2013, the team came to me and said, we are finally at the point where we think it's important that we have in-house legal. And, my immediate instinct was, great, whatever I can do to help you, let me know. One thing, because I was an established partner in a law firm, I thought I had achieved exactly what I'd set out to do. And so I didn't really consider maybe doing the role. But here I am, 10th anniversary at the end of March 2024, and I'm still there. So that's when I talk about, when I say luck, it was luck that I was, involved in the legislative process, and it was a lot of hard work thereafter, and that's, I think, components that you will find direct your own careers.
Thank you. For me, it was a combination of prayer and perseverance, because like many students, I had this interest from day one, and I had this, what I thought was a brilliant vision of how I would work so hard in school, and I would serve on the right journals and do the right things and get the right grades, and I would get this amazing job as soon as I graduate, and life would just be perfect. And that's not exactly what happened. Prior to joining the Vikings, I was a lawyer for the WTA Tour, so I was working in tennis. And prior to that, it was a mixture of private practice and in-house. And I will say in the beginning, it was a little bit challenging because I wasn't getting those opportunities that I thought I wanted. But in retrospect, I can look back and I can say that every single opportunity I had prepared me for where I am today. Every job taught me something that I needed to know, whether it was a skill set, whether it was a hard skill or a soft skill, whether it was working through different dynamics, and I'm using every single one of those experiences today. So if I can leave you with anything and you don't remember anything else I say, I hope that I encourage you to keep a healthy perspective, to just remember that one day you can translate those skills into the opportunities that you're looking for. And so I hope you stay encouraged along the way, because there are going to be detours, but what matters is how you navigate them.
Yeah, I would like to also say thank you for hosting us today. I would, obviously, I'm a little on the newer edge of this panel. I've only been working for the Wild for about 2 years, and that was my first job out of law school. Before that, as Marshall mentioned, There were a few bartending jobs. Those were mostly to afford to live during law school while I worked there part-time. But luck and timing is kind of what mixed together to help me get this position. I got a job notice while I was waiting to hear back from my bar application and another job, and I applied and I went through a lengthy interview process with the Minnesota Wild, and I ended up where I am today. So it kind of all came together right at the right time, but certainly, perseverance throughout law school and doing these kind of things that you guys are doing right now helped along the way.
Thank you all for that. Brief follow-up for Mary, because like you said, the Twins didn't have a legal department. And you've overseen kind of the expansion of that legal department. For those of you in sports law or the SEM organization, you may have seen Mary and her team speaking in a class or at an event. What's that been like to oversee, and how do you look for people to join your team?
Well, I think when I really had no idea what I was actually getting into, When I went there, I had all these years of really as an M&A transactional lawyer helping people buy and sell businesses, which was really fun. And although, it's pretty challenging, but I thought, well, how hard could it be, right? I can do this. But I would tell you, in all honesty, the learning curve of the business of baseball, it was steep. But I do believe that all those years of practice as an M&A lawyer, because when you do that, you don't know the business that you are going to sell or buy. But I can tell you, at the end of 4 months, you do. You understand the contracts that keep the CEO up at night. And so that very same process is really what I utilized. I call it peeling the onion as I learned the business of baseball. So yours truly was the only lawyer on the ground for like 3 years. And during the interview process, even though they knew me and I had worked with them for like 7 years, I had a fairly robust interview process. And I recall someone saying to me, well, what if you don't have enough to do? And I said, well, I'm pretty resourceful and I'm pretty sure that I can find something to do here. So when I got there, I would get, I had typically worked with the folks in the C-suite. So they knew how to work with lawyers, but the vast majority of people within a club's organization, these are lower level business people. Many of them are very new because you're getting them fresh out of college. So they probably had never worked with a lawyer and they were pretty sure they didn't want to. So I would get these very tentative calls, I have a contract, Mary, do you want to look at it? And I would go, oh yeah, I do want to look at it. So I would look at it and mark it up, and I could just feel their angst, like, oh God, we're never going to get this done. And I'd say, don't worry, it'll be okay. I've only asked for things we need. And we would get it done and we'd move along, and they would call back and go, hey, I have another contract, you want to look at it? And I go, yeah. And so I am a strong believer in winning hearts and minds one at a time. So from that start where people weren't sure, is this person going to add value, to today where, things come up and I have tremendous ambassadors among the business people, and they will go, well, does Mary know about this? Have you talked to Mary? So this is over a span of 10 years, and to Marshall's specific question, I now have 3 full-time lawyers working under me. And the workflow, those who've heard us speak before, we talk about our weekly to-do list, which is about a 10-page, single-spaced document of every assignment that we have outstanding. And it is all day, every day, the amount of work that comes through our legal department. It's pretty amazing. Sometimes people will say to me, I'm surprised, all these things, and of course the industry has changed, so there's a lot more things to worry about. But yeah, so setting up this department, I created it from scratch. I've lived in a law firm where you would go, could you bring me the file on X? And I would be fortunate if I could locate a signed copy of a contract, because that's not how they thought. So I can tell you now that I have a robust file system, and I can file I can find anything on any given day. So that was my experience. That's been the last 10 years. And it's like a buffet, of legal issues. In deal work, you get out your stock purchase agreement, you get out your asset purchase agreement, and away you go. But here, many, many issues that come to me are new. There's a slightly different bent to it. So you have to be, I always say, if you want to do this and enjoy it, you have to be nimble in your thinking. You have to be available, and you have to be nimble. So that's what it's like to set up a law department in a sports team. Yeah.
Kind of following up on that for the other two panelists, what is it like to work with the other departments in your respective organizations?
It's interesting. I think you have to be a communication chameleon. And to your point, Mary, I think it's important to make sure that you earn the trust of your colleagues so that they come to you before there's a fire. I think part of being able to communicate effectively across the board means that you do have to be nimble in your thinking. You have to understand what's important to their department, because even if it's a multi-department project, each member of the team may have a different scope, it may have a different area of expertise, may have a different why behind their ask, and making sure that you understand all of their perspectives so that you can communicate to them effectively and you can find a solution that hopefully makes everyone happy is the key. So I think it just requires you to be nimble, to think on your feet, and to also understand their business and what's important to them.
Yeah, similarly to that, we have multiple departments and multiple different entities with their own more departments within it. So we're not just the hockey team, we're also, we also own the arena, we own the Rivers Center, we own the Iowa hockey team, our AHL team, and all of those different entities have their own marketing departments, their own sales departments, their own partnership departments. So it is a delicate balance of, doing what you need to do as an attorney and reviewing contracts and trying to make sure everything is in line, but also working with those departments to get what they want to get done, which are, event activations or certain marketing promotions, things of that nature. So you need to kind of balance being personable and someone that they're not afraid to come to, but also drawing that line of where the law is going to interfere with whatever they have in mind.
Yeah, I have to say something, what Ben said, and I think this is important, is you don't get to say no. Yeah. And part of what they're talking about here is, I once said to Dave that I'm a solutions provider. And he goes, really? Is that how you think about yourself? And I go, absolutely. Because you don't get to say no. You have to understand, I'm really, the overseer of risk management. That's how I think about it. And so I have to facilitate the business objectives, and I want to be able to do it in the way with the least amount of risk. I can't avoid it, but I can mitigate it. And so we have to find a way for our business partners to achieve their goals in a way that is of least risk to the organization. And, we could entertain you for hours on some of the crazy questions we've been asked. But we have to find a path forward because the train has already left the station. So it is far better if, you talked about it, if your clients come to you before and they go, hey, we're thinking about doing X, it's far better result than if, they are already to the next town and you're not even on the train. So that is just a critical, like I once, someone described it, do not be the person where dreams go to die. And that is really the goal, I think, of being in-house counsel. And that goes to being nimble. Because when you work in a law firm, and I spent a lot of time in one, you are in your lane, period, end of story. And I can tell you when I hire outside lawyers today, if they're that kind of person, Yeah, I want to talk to the most senior lawyer in the law firm because they have to understand the practical realities. You know, I understand there are risks, you know, but what's a showstopper here? You know, what's the big idea of the risks that I need to avoid? Because I can't avoid all of them. So when you are an advisor in a law firm to people who hold positions like we do, you know, you got to be able to understand that we have a business goal that we have to achieve. So help us find a solution. So even in my outside counsel, I look for solutions providers. And it will give you angst if you're in a law firm, but you have to be able to do that. And those are the most valuable outside advisors, at least the ones I look for. I don't know, I'd be curious.
I agree 100%. Solutions and also being succinct and efficient and kind of to the point is
do
key.
not waste my time. Yeah.
Yeah, we don't want to be known as the no department that people are afraid to come to, and then things go on without us even knowing about it, and we find out too late, kind of to that point. We want to welcome those initiatives. We don't want to be known as the no department, but to a certain extent.
Well, and on those rare occasions when you go, God, just can't get there, you know, what's the second choice? You know, they believe you because you've already established trust with them. And I think the context where I most often say no is on the IP side. You know, that's usually where the rubber hits the road. You know, somebody's got a registration out there and we just can't go there. So then you're on to plan B, but.
Yeah, one of my only, and actually just so happens to be most recent no's, was something that happened without our knowledge that we found out about afterwards. It was, you may have noticed it, you may not have. Personally, I hope you didn't notice it. Our social media department launched an initiative a couple weeks ago for our 90s theme night for a game. And part of that was posting our players in registered Pokemon cards with the Pokemon logo and all of those things. That one just had to get taken down. It was, and when I went to speak with our social media department about it, they said, "Well, what's the issue? We left the copyright symbol on the bottom of the cards," and I go, "That's to let you know it's copyrighted and you can't infringe upon it." So that's again a rare no, but that one was a no. And they said, "Well, we have so many viewers, so many people like it." And I go, "They'll like everything else too, but this one's got to get taken down."
That's one crazy question you got asked. You all kind of mentioned you get those asked. Do you have a story about maybe the craziest question you've been asked?
Trying to figure out what I should share.
I'll share one. Well, I mean, it's not even that crazy, but it sounded pretty crazy at the time. So when you vote for players, you know, in the All-Star game, so Dozier was a player at the time, and they wanted to put a bulldozer out on it's an elevated pedestrian walkway into the ballpark. And I'm going, what? You know, you want to do what? And they go, well, just be for a couple of days. And, you know, so what do I think about? Well, A, I don't like, you know, the heavy load of the bulldozer out there. A, I don't like the fact that it's, or B, that it's unattended and some, you know, toddler goes out there and cracks their head when they fall off the bulldozer. It's things like that, you know, I have learned so much about insurance sitting in this chair that it's mind-numbing, actually. But these are the things I think about, worst-case scenarios. What's the worst thing that could happen? And so that's what I worry about, is personal injury to somebody. I will share one other story. At the time that we were, you know, still building the ballpark, for those of you who've been to Target Field, when you walk up 6th Street, there's a pedestrian walkway that is, in fact, in airspace over an operating federal highway. And the piece of information that's of interest, I think, is at the time that the Minnesota Ballpark Authority and the Minnesota Twins were negotiating with MnDOT this elevated walkway, the bridge fell down over the Mississippi River. If you don't think that that didn't make those conversations uncomfortable, that would be an error. It was tough sledding because, what protections did we have in place relative to the construction of this elevated walkway? And so I can tell you the maintenance obligations relative to that pedestrian walkway are significant for the very reason that we had a real-time situation where a bridge fell down and people died. So that was a funny one and a not-so-funny one.
I wouldn't say the requests, and that's, in this role and previous roles as well, I wouldn't say the requests are crazy. I would say that they're thought-provoking. And some of the more thought-provoking ones pertain to using a drone to capture footage within a certain proximity of the airport and the related FAA obligations and regulations. Another one pertained to suspending heavy equipment inside of a sports arena. And of course, there's a ton of risk associated with what happens if a cable breaks and someone gets injured. So I'd say those are some of the more interesting and different, but maybe not necessarily crazy stories.
I just have to add, because how many people in the room think of drones as aircrafts? Probably, a few. Who would have thought? But it's actually, they are regulated. So, it's a no-fly zone for drones. And in relatively recent history, some kid was out with his drone and flew over target field and it shut the game down. So they take that really seriously. So on rare occasions when we want to use a drone, there are MLB regulations and a process that we have to follow to permit that. So, it's just all these things and these pieces that you go, oh my God, I can't believe I'm being asked this question. So it's really about, and I think you said it best, it's about building this body of knowledge, being nimble, and from everything that you learn, being able to apply it to the next unusual circumstance that comes your way. And they will come your way probably weekly, maybe daily. But it's about building this body of knowledge. I didn't just spring out to who I am today. There were many, many times I sat for years in the back of the room taking notes. Trust me, you have a lot to learn. When you get out of law school, man, that is the bottom rung on your journey, because you have a long way to go. So be humble in that. Be receptive to the knowledge that you have yet to learn. And, I've had some incredible mentors over the years. And it was the Socratic method. I'm sure we're all familiar with that. My first lesson in drafting an asset purchase agreement was the most painful experience of my life. I sat at a small round table on a Memorial Day Saturday with two senior partners, and we walked literally sentence by sentence by sentence through the reps and warranties of that agreement. And at each and every one of those, they'd go, well, what do you think about that, Mary? Does that give you any pause? And after this 6-hour exercise, and it was brutal, I spent the rest of the weekend rewriting this document in a way that would be acceptable for our client. And it was probably the most instructive moment of my career as a beginning lawyer. It was painful, but it taught me, things you are not going to learn in law school. You're just not. And so the journey of learning is really just beginning. And you have to embrace it. And there will be moments of pain, but there will come that day when you'll just, there's angst about it. Like, what am I not thinking about? That will not leave you for years. But then one day, and I know the exact moment in time when that moment came to me, in that situation, we were firing a CEO of a public company. And we put together this little book, and it said, If you leave nicely, this is Plan A, and this is what the news release will look like. And if you don't leave nicely, this is Plan B, and this is what the news release looks like. And so we had this, and his high-powered lawyers flew up here, and yeah, we had this conversation. And my senior partner, so we met with them, and they said, "Oh my God, this is terrible," And my senior partner turns to them and says, "I think there's some misunderstanding. You can take Plan A, or you can take Plan B, And there's some details, that Mary can work out with you." So we were dismissed, and I spent the next 30 hours figuring out the details. And that moment came when we went to have the agreement signed, and the CEO who was being released shook my hand and he said, "Mary, I just want to thank you, but for you, this would not have gotten done." And that was my moment. But I had spent, 11 years in the chair at that point. So you've said it best, you have to be patient. There's so much yet to learn. But it's fun. When you get to that juncture, it's fun. So I'm here to say you can survive it.
Yeah, absolutely. But to briefly backtrack onto the drone topic, since it's been brought up, we recently had an issue with that at our arena. Our marketing came to us wanting to fly a drone in arena during a game with 18,000 fans in attendance. Never really considered that becoming an issue prior to working for the Wild, but that's just an example of things that come up that you would never expect. So I had to do a bunch of research, write a legal brief for my general counsel to review, for him to then explain to the VP of marketing why this is probably a terrible idea. But no surprise, we still went forward with it. And to my knowledge, there was no issues other than we get the incident reports after every game. And there were a couple of notes about multiple fans complaining about a drone buzzing around their heads. But outside of that, it worked out. For a crazy story, I should preface, this is not my story. This happened before my time. This was with my general counsel and my previous boss. As I mentioned, we own and operate the AHL team, the Iowa Wild. They're currently located in Des Moines. Prior to 2013, they were in Houston, Texas, and they were called the Arrows. While they were there, it was a little, to my understanding, a little bit harder to manage because we were all the way up here in Minnesota, and they were kind of in the wild, wild west of Texas. So they came to the legal department with an idea to have our mascot go up in a two-seater plane and jump out of it into a field of school children with a parachute with the Houston Astros on it, and it was going to be a huge marketing initiative. That was a no, and that was actually a question that was asked of me in my interview process, what I would do a few years ago, and my answer was no. A more recent one that you just wouldn't really expect in law school or going to work at other firms or in-house counsel positions. We have events at the River Center all the time, obviously. We have to do all the agreements for those. One of their events they recently had, they wanted to bring in llamas. It was a sensory event, and these were friendly llamas. So we had to figure out a way to make that work for them, make sure our insurance would cover such a thing, because that's something I hadn't previously thought of, how often we work with our insurers for all the different things that we do, whether it's the arena, the River Center, the team. But yeah, that was a more interesting ask as of late.
Have you gotten a zip line request yet?
Not yet, thankfully, but I'm sure it's coming down the line.
Yeah.
Great stories from everybody. So as sports fans, people, of course, are familiar with, the season versus the off-season for a player, a GM. But what does it look like for a lawyer in your respective roles between the season versus the off-season?
Transparently, I don't really notice a difference in my workload. I think there's always a supporting function. There's always work to do to prepare for the next event or the next big thing. I will say, here I haven't noticed the difference. When I was on the WTA tour, maybe toward the end of the year was kind of the slow season because tennis is an annual sport, so it doesn't have much of an off season, but I don't really notice a difference in terms of the amount of work. Sometimes it's just the types of projects and the types of requests that come in.
Yeah, I would agree. Certainly the amount, it comes in waves, but it's relatively steady throughout, either whether you're in season or out of season. For us, typically our out of season consists of a lot of our sponsorship agreements, our suite and loge, they're annual contracts, but those all typically come up in the springtime because we want to get them locked in for next season. So like right now on my docket, I have roughly 30 suite agreements that need to be either reviewed or written. During season, it varies all the time. I mean, we've all given you some examples. Those just come up at any time, really. But player contracts are something that we typically work with more often during season. Certain marketing promotions we'll do. And then back to off-season, actually, we do a lot of our experiential marketing. So we do something called the Road Tour, where our experiential marketing team goes out to different towns throughout Minnesota, and they bring an inflatable hockey rink and other activities for people to play. But what the average person might not realize is that we need insurance to cover all that. We need event agreements for all of those. So that's a lot of the stuff that we'll see during the summer.
A couple of you touched on IP, and it seems to be a growing area of importance for teams. So what do you each do in your respective roles to help protect the data for your teams?
Well, I think that's twofold. So there's the IP part about campaigns and, that they launch. Your marketing people they're people of many ideas. So you have to always clear marks. But I think on the IP side, it's just this crazy amount of software agreements, hosted, maybe it's a subscription service. And so what I'm constantly worrying about is, what's being created and who's going to own that data, because that is the key. And people, I don't get very, especially, and I'm sure it's true in all these sports, there's so much biometric data out there. And, it's players, how their body moves, we're capturing all of that, we're uploading it to a system. And the owners of that software, they want to prove the efficacy of their product. So they want the ability to utilize that data to prove it out and sell it to more people. And, I often find myself calling the folks down in baseball and go, so exactly how is this thing gonna work? And, what's it doing? It's got cameras, it's got little robots, and it's a huge thing. And we spend an inordinate amount of time on those software agreements. Now, it's not only the analytics relative to the players on the team, but it's business analytics. So you come in the door at a stadium, they are tracking you. Did you go buy a hot dog? Did you go get a beer? Did you go to the merch store? Who'd you come with? They're collecting all of that data, and why? It's not any different than your phone. You do a search, and then for the next, 6 weeks, you're getting ads on a particular pair of shoes, maybe. It's crazy. I defer to these two, but at least in my world, I'm thinking about data daily.
Absolutely, for me too. I think ownership rights for deliverables for the SaaS agreements and the PaaS agreements, the platform as-a-service agreements are key. Along that same vein, though, I think we spend a great deal of time thinking about portfolio management, and every sport is a little bit different, and the NFL does support its teams quite a bit in this space, but making sure that if our IP is inappropriately used, we're issuing those takedown notices, issuing those cease and desist letters, and then pursuing dispute resolution if necessary. So that's another part of it. And I think in terms of like the marketing and the campaigns, sometimes it's a question about whether our marks are being used appropriately, but then sometimes it's a question about whether this particular marketing initiative can move forward with the necessary permissions from the other party. So for an example, I was once asked about this proposed project where the marketing team would take a well-known toy owned by a well-known company with a very robust intellectual property portfolio management scheme, and they're not playing games. And in addition to having trademark protections on the logo itself, they have trademark protections on the shape of the product and how it's used. And so the question was whether we can use this product without permission for this promotion, even though we're not using the logo. And that's one of the rare instances where it's not a no, it's a we shouldn't, and here's why, but here's what we can do. Here's how we can approach the counterparty and get the necessary permissions. So lots of IP implications, in short.
Yes, no, IP is definitely something that, again, I hadn't expected going into this job, but it's something that I've had to develop over the past couple of years, a knowledge in, and we own our specific trademarks, but the league owns the Minnesota Wild trademarks. So what I mean by our specific trademarks would be like the Iowa Wild, the River Center, the Herbie's on the Park, which is our restaurant that we own, Hockey Lodge has a registered trademark. So we handle most of those in-house, meaning we register them, we have to renew them. So that's one aspect of it. The other aspect is, again, looking out for infringement. So, we're 3 in-house attorneys. We do use outside counsel in some circumstances, depending on what type of infringement it is. But if it's a company making T-shirts halfway across the world and selling them on Amazon for $5, we can try, but it might not really be worth our time. We'll send out cease and desist letters. But if it's a local company clearly profiting off our mark or the Minnesota Wild trademark, specifically the NHL will get involved. They will get their in-house counsel involved. They will get outside counsel involved and make sure that stops immediately. A more recent one, that happened at the beginning of the season. There was a local company using one of the Minnesota Wild marks, and the NHL requested that they immediately cease and desist and also send all of the unsold product to their office. So that's something that we don't typically do, but they did not want any of that going out to the local market.
Everybody be thinking of your questions too. We will save time at the end for audience questions and have a mic going around. So aside from IP, what do you all anticipate might be some of the biggest issues to cross your desk in the next few years?
Go ahead.
Oh, no, you go first.
Oh, yeah, you can go first.
I think it's actually related to IP, although it has broader implications because data privacy is such a hot-button topic. But Mary, you mentioned it earlier, the importance of understanding biometric data and the implications for collecting that data, because it's not just the players, it's fan data. There's so much research and so much analysis that goes into understanding fans and what makes them tick and what makes them purchase things and how often they purchase things and when during the game they're making these purchases. And so following the legal landscape to understand not only the data privacy implications, but just also what you have to do to be able to collect that data and use it responsibly, I think is going to be key.
It's something that's developed in baseball, and the name escapes me, but I'm old. But there's new technology coming out that you can sign up for and as a fan to improve or enhance your egress and ingress to facilities. So what it does is that you opt into the program, and it's essentially identifying you based on your own biometric data that you have agreed for this platform to collect. So it collects the information and it creates an electronic token of your image. And so the machinery or the equipment identifies you based on this token. So the initial snapshot that it takes of you, that isn't retained, but it goes through this algorithm and creates a token. And so the system knows the token. And so, Mary's coming to the game and she's bringing 3 of her friends. And so it will allow you to pass through the gate more quickly without showing your tickets. Your bag's still going to get searched. But the goal is to get you in the stadium as quickly as possible. And so, we've had some discussions recently relative to, is this really collecting personally identifiable information? Because, it no longer has your hair color and your eyes, and it's just created a token of what that means, through this algorithm. And it's really fascinating when you think about it, because I'm like, well, that's probably okay because I opted into it. And it's not like having my mugshot somewhere. So that's the nuance in these, data privacy and protection. Part of it is you're opting into it. I mean, I do it all the time. If I want access to something, I have to click a button to go, yeah, I agree. And so that is not going away. And I think the other, I would just say a slight tangent on that is, I think the next thing I worry about, and I'm sure, both of my colleagues here, I must get 10 emails a week from somebody or other who wants to sell me the latest and greatest AI tool. And I'm like, yeah, I don't think so. So, be worried about how are you going to provide value going forward. I got to tell you, I write contracts from whole cloth. And so the idea of some computer, there are certain, I think, and Ben mentioned it, sponsorship agreements, suite agreements, things that maybe lend themselves to, a template format, so to speak, but just generically, writing letter agreements that are very specific to a situation. Yeah, I'm not turning that over to AI. Don't you have that experience too?
Yeah, no, absolutely. That's privacy the league's privacy policy was a hot button item last season. All the teams had to redo all of their own individual privacy policies to get in line with the league for all of these developments that are ongoing. But another thing that has happened since I've started with the Wild, my first season was the season that we did jersey patches. It was a new thing at the time. I think we were the 5th or 6th team to do it. And if you're not familiar with what the jersey patch is, it's an advertisement on the player's shoulder. From a fan's perspective, I think the majority were not super pleased about it, but it's revenue for the team. And that at the end of the day, the league, the team wants as much revenue as they can get. So I don't think that's gonna go away anytime soon. Even at this point, I think, so our jersey patches, TRIA, which is Health Partners, we've since added a logo to our helmets as well for Toyota. And so they're gonna find everywhere and anywhere to advertise on the player, and I think that'll keep developing. My last season, the new thing was DEDs, which are digitally enhanced dasher boards. Our dasher boards are the boards. They're the boards in the rink, and obviously whenever you go to a rink, there are advertisements all over them. They're white boards. The digitally enhanced dasher boards allows these advertisers to constantly rotate their ads. They don't have to be permanent fixtures. So these are for when we televise games, you can purchase a dasher board to be on for 30 seconds, and then it'll rotate to the next advertiser. When it first went out, there were a lot of complaints about players wearing white jerseys and blending in with the boards, or the puck disappearing, or what have you. The technology is developed since then, and I believe it's almost unnoticeable. But if they thought of that, it's kind of, what else are they going to keep thinking of? Because again, at the end of the day, it's always about revenue. It's about gathering as much revenue as you can, because we're a business, and fans don't always realize that, but that is typically the reality.
A chance for some more entertaining stories here with this one. What are some of the biggest misconceptions about your respective roles?
That it's all fun and somehow less serious than other types of work. In my opinion, there's technically no such thing as sports law. It's just every other practice area applied to the sports industry. And for me, that's just what makes it inherently interesting. But it's not easier, it's just interesting.
Yeah, exactly. I would share that absolutely. It's no different than really any other work. Having a client as a sole business, working in an in-house capacity anywhere, you need to be always thinking on your feet, always aware of what that specific client, in my instance, it's the Minnesota Wild, will come to you with that day, and they kind of expect you to know what they're asking. So it's really no different than any other in-house job, outside of the fact that you get to go watch a hockey game when you want.
I do think that it is different than being in private practice. And there is, you will hear this murmur out in the real world that, oh yeah, the people that go in-house, they got it much easier. And I would argue that's not true, because in private practice, your client calls you and then they scurry away and, all's well. And at some point you get to say goodbye to them. And when you work in-house, yeah, your client it's 10 feet down the hallway. They are always there. So you never get a break from it. It is, in my situation, it's baseball all day, every day. And I'm not complaining. I'm just saying it's a very different environment. But I think one of the advantages is that you are truly a business partner. I am there to help make informed business decisions. I don't get to make them. I get to help inform them. And I always tell this story. Not too long after I got to the Twins, Dave said to me, I gave him my spiel on whatever the issue of the day was. And he said, Mary, I don't know if I agree with you. I said, you did not hire me to agree with you. I'm giving you my best advice. And I would say the track record's pretty good. And so it is fun to be part of something. And I think, on the flip side of that, I remember my first fan appreciation weekend. And because I was a senior executive, I got cool stuff to hand out. And so I had an autographed Joe Mauer ball. And it was a rainy, icky night. And I went out in the stands, to find someone to give this ball to. And I happened upon a family. It was a mom and dad and a little boy and a little girl with pigtails. And she had a little pink, mitt in her hand. And I said, yeah, I'm looking for a Joe Mauer fan. And her mom took the little girl by the shoulders and shoved her in front of me and turned her around, and she had on a Mauer shirt. And so I gave her this ball, and, I'm sure she thought, who's this old lady handing me this ball? But I believe that it is a moment in time that she will not forget. And we take very seriously making magic moments for people. And even I, as a lawyer, get to do that. And it is so rewarding. Or handing out a baseball to a grandpa and his grandson. So these are opportunities, and I'll share one other. After Puerto Rico and the horrible, horrible hurricane, a contingent from the Twins, primarily of senior executives, including ownership, went down to Puerto Rico. We brought our mascot with us despite the hideous heat down there. If you've never been in a mascot uniform, it's hot. Anyway, so we brought him down, and we went and helped clean up literally homes that had been become inhabitable through the storm. And one of my favorite pictures is after a long day, pretty grimy, sitting on the step, someone snapped it of me, Antonio. And these are opportunities and moments in your life that you just don't always get to do, and I'm so grateful. So even with the hard stuff, I would say it's hard. There are moments of sheer joy.
For sure.
Notice how they're nodding? Yeah, I'm not making it up.
Yeah, definitely rewarding in that aspect as well. As far as differences go, is you could get to see the product that you're helping with. So like my big moment was working on a bunch of sponsorship agreements at the time and going and seeing those in the rink, and that was back when I first started. But those moments differ from other jobs, I would say. Actually seeing what you are helping with it's encouraging. It keeps you going when you're doing the not so fun stuff.
One more from me, and then we'll move to audience questions. You've all kind of touched on it a little bit, but each organization has its own culture. So what have you seen as the culture like at your respective teams? And to the extent you do have work-life balance, what does that look like for each of you?
I think he set me up because he knows my answer to this. Yeah, work-life balance. Okay, whatever. So the club pays for my cell phone, okay? So when it rings, they fully expect that I'm going to answer it. And it really doesn't matter when. I shared a story last night. I'll share it with you because I think it's kind of funny, actually. But some years ago, it was the draft and there was some issue and I had to get on the phone, and my husband happened to there was a game that day and I was at home because we had a wedding in the evening. And so I know shockingly, I thought I would take a bath before attending this wedding. So I just get into this wonderful bath and the phone rings and I hear it ring and I think it's my husband. I go, whatever. So it runs its cycle and then it rings again. And now I'm getting irritated. And then it runs a cycle, and then it rings again. So by this time, I'm climbing out of the bathtub, going down to the kitchen, picking up my phone, and I'm not happy. And of course, it's my husband. And I call him and I go, what do you want? He goes, well, Dave's looking for you. And okay. So I quickly hang up. I'm standing there with my towel on. I call Dave. Anyway, the game at the ballpark ends. Lauren drives all the way home. It's a ways. And I'm still sitting on our living room couch in my towel, talking to my client, trying to resolve an issue. But it just demonstrates when you are in these chairs, your need to participate and to become part of the solution, it's not going to always be convenient to your personal life. And at the very beginning of this, I talked about you're either in or you're out. It is not dissimilar for major league players, and we all work for businesses who engage highly paid major league players. If you want to be a major league player in a loss setting for a sports team, then you've got to be all in. And players are expected to show up and give their best every single day. And I would say, my position, he knows this, is that you should do the same. If you want one of the chairs that we have, so I'm kind of interested, I know that's a little edgy in today's world, but I will tell you, I don't regret it. I have a choice. I don't have to be there, but I love being there. And I know that that is what is required if I want to be a full participant. So I don't know, what do you think?
I'd say in terms of the culture, what I've noticed is that it's highly collaborative, and I feel like that's a bit of a hot button term these days, but in this organization, I've noticed a difference from other organizations where I've worked. And what I mean is that, I'm often called into strategy discussions, and it's not typically a legal function per se, but my team wants me in the room when they're discussing KPIs and how they're developed and how we're measuring them and what makes sense for years moving forward, and how we want to approach discussions with a potential partner and how we want to ensure that multiple partners can coexist in similar spaces. And these are, in previous roles, I noticed typically a decision's made and then legal gets the agreement and you need to paper it to the best of your abilities. But here I've been looped in a lot earlier. And that was eye-opening and that was telling, and I'm grateful for that. In terms of work-life balance, transparently, I have never been the best, but I learned a new term recently, and it's work-life integration, and that's what I'm working toward. So for me, it's just reminding myself that there is always going to be something pending on my to-do list. I can't get it all done today. And so when I've given my best and I've reached a decent stopping point, I'm allowing myself to go to bed. I'm allowing myself to have a moment. Sometimes it means just taking a 15-minute break and thinking about something different, but it's just whatever I can do to achieve a little bit more integration, I consider to be a win.
Yeah, speaking to the cultural part, as I've mentioned, we are the Minnesota Wild hockey team, but we have all of these other different entities under us. And so we have employees under all of those different entities. The arena alone has 300 part-time employees throughout the year. And then we have all of our full-time employees for the River Center, Minnesota Wild, Iowa Wild. So we make an effort to kind of collaborate all of those different people together, whether it's a few events during the year or introductions. A few weeks ago, I went down to Iowa Wild just to see a game and talk with the people face-to-face down there that I work with every day. Because even though I see the people that work for the Minnesota Wild every day, I'm not down in Iowa every day. So that's kind of the cultural aspect that we try to bring all of those people from all the different organizations under one umbrella and meet. From a work-life balance situation, it's I think Mary hit it on the head. It's you have one client and your client is always needing something. Now that's not to say that an average day isn't 8 to 5, 8 to 6, but if they call you on a Saturday night with something random, such as, this is public knowledge, it actually happened before I started working, but someone opened fire at the Trailer Park Truck Stop, which is a bar right outside of our arena, a few years ago, and it was before one of our concerts. My general counsel got the call and said, from the owner, and saying, what do we do? Well, that's not even our bar, but obviously we were involved in some capacity. More recently, there's been calls from Iowa in games where situations have gone awry, and they play their games at night. They call at 8 o'clock on a Saturday, and they need advice. You have to answer, but it's not like that all the time. But it is something you have to be mindful of if you want to work in a position like this, to always be available. I always tell my general counsel, whatever you need, let me know. And I know that's appreciated. So it's tough, but it's rewarding as well, which I'm sure everyone in here has either in law school or gone to law school and can understand that from that perspective as well.
I think one footnote, if you would allow me to add, is the beauty of it is that today you just go everywhere with your cell phone. And so it used to be, you kind of had to come in the office, and now I can literally be anywhere, so long as I'm accessible by my cell phone. So I have that, to me, that is huge flexibility. They don't really care where I am, and before I went to the team, I said, just so you know, I am not coming to every game. And the operations folks know that, so maybe we have an unruly fan and we need to trespass him. They will reach out and let me know, hey, Mary, we're tossing so-and-so out the door. So they know that they can communicate with me. They can always reach me on my cell phone. That is always on, literally. But that is a flexibility and a component that we all, I think, probably enjoy.
Questions from the audience?
Two questions, I guess, from me, and one of them you might not be able to speak to a whole lot, but I want to ask it anyways because it's been in the news a lot. The first question that I would have is regarding how each of you in your capacities collaborate with the league of which you're affiliated. So what is your relationship with MLB like, NFL, NHL? And then also, Ben, I know you've spoken about this a little bit, but how do you work with your affiliate organizations as well? So Mary, obviously, very extensive. Twins have 5 affiliate organizations. How do you work up and down, I guess, at those different levels? Then on the second piece, if you can talk to it at all, TV rights, streaming, broadcasting has been in the media a lot. Mary, I know you're laughing. The Twins have been on the front page of just about every news article covering this. Any comments you can make as it relates to whether it be your current situation or maybe looking further out into the future? What is the future of the streaming or digital access of the content that your teams are putting out? How can fans expect to access it 5, 10, 15, 25 years down the road, as it looks like the RSN model is basically dead now? Sorry, there was a lot there.
Yeah, I was like, wow. Oh, league, yeah. Well, I'll go first. So collaborating with the league, and they operate differently as among sports. So in baseball, and Ben talked about IP, so we have to clear IP. Enforcement comes at the league level, which is actually very helpful. So, when people, are trying to capitalize and use your marks, a call from MLB, cease and desist, they're going to take it down off the platform, they're going to contact people, and so we don't have to, it's nice to have that enforcement arm. So there is, I would say, a tremendous amount of collaboration. I don't know what the number is. Last night I guessed that I think there's probably 50 lawyers at the league level. And they are assigned to various, there's the marketing people and the labor lawyers and the this and the that. And so, just understanding how to navigate that. But I would say the relationship is robust. So I was I'll give you an example. When I first came into the league, speaking of IP, in the league, they're kind of like big, the father telling me, don't worry, it's okay. And I wanted to know what the licenses were on our marks that had been granted to others, because they also do licensing for our marks. And they go, well, don't worry, we've taken care of it. And I said, well, I would like to know. I would like a full list of our registrations, and I would like to see the licenses. And I had quite a engaging conversation with a fairly senior person at MLB, and roll forward a year later, out of the blue one day, I get a zip drive, and voila, I have a list of all the trademarks and all the existing licenses. And that following fall, I go to the club council meetings, and this young woman walks up to me and she goes, Mary, I want to meet you. She said, you were my #1 objective this year, to get to each and every club licenses and complete lists of their registrations. And I happened to be standing next to the GC from the Rangers, and she goes, yeah, that was super helpful to have that information. I was like, well, we should have it. So it is a dialogue. They issue all kinds of rules and regulations, so you need to have a really good working relationship. And the second part my favorite, TV rights. So each one of the leagues that are at the table today, we have this content. So we have to find a way to monetize it. The traditional model has been what's known as the RSN, the Regional Sports Network. And that used to be primarily a subscription cable model. It's also known as linear distribution of content. And you ask where it's going. It is going direct to consumer, DTC. That is where the future is. Each league, again, slightly different, but I will tell you in baseball that DTC, those interactive, we call them interactive media rights, are held by the league. So what Diamond's really upset about is that's what they need and that's what they want, but they do not have, with the exception of a few clubs. And the Twins are not among them. So that's the future. And I think what's interesting to look at, so as people are cutting the cords on cable, you are seeing these products come into the market. You know, for $20 a month, you can watch every single Twins game. And so Diamond has put out there this, you know, their shiny new toy is this potential Amazon relationship. So that you could, for a fee, because it will be tiered, you can have access to content. So I think it will be very interesting. The model still has some value, this linear, but it is dying. It's no longer really their moneymaker it was.
I'd say the NFL also has a very robust collaborative approach with each of the member clubs. And for me, that was different because I came from the WTA tour where we were, in essence, the league, although it's a very different sport, different structure, we were nonetheless the decision makers. And then I came to a franchise where we often do report to the league for lots of those decisions. So things like our IP portfolio management, a lot of that direction comes from the league. Anything from policy development to, you know, expectations around fan data and PIA process, you know, privacy impact assessments and things of that nature. So very robust collaboration, lots of support, and it comes in handy. With respect to affiliate orgs, so I think it just kind of depends on the team, the ownership structure, and the sport. For us, you know, we have common ownership with the Orlando City Soccer Club, but they're nonetheless two different sports. Notwithstanding our common ownership, we do have two groups of professionals who are kind of running each show, and then we overlap as needed. And then with TV rights, I think you're absolutely right. I think, you know, direct to consumer is the future. Streaming is here to stay. I think now that the technology has become more democratized, there's just no going back. I'm not sure about affordability, though. I do hear a lot of criticisms about the cost of different streaming platforms, and I'm not really sure of what the solution is, but I do expect direct to consumer is here to stay.
Yeah, as far as the league, I've kind of touched on it already. They own each of the franchises' main trademarks. So anytime something comes up with them, they're always there to help. I will say, typically, if we can handle it in-house first, as whether it's a C&D or more than that, they prefer that. But I gave an example of one of those bigger initiatives of the local store earlier. And that's when the league will step in. And as Mary mentioned, when you get a 5-page C&D and a call from the NHL, it's a little different than our quick one-pager. Beyond that, there's general memorandums that they'll send out throughout the year. There's things that teams need to be in line in. But at the end of the day, we also operate as our own individual business. So they're there when we need them, but they're not always overarching, I would say. And another aspect where I've seen it come up when we're dealing directly with people at the league office are playoffs. There's a ton of initiatives that they like to do throughout the entire league when playoffs come around, so we have to collaborate with them, get agreements going of whatever initiatives they're looking to do that year. Similar to the Twins, we are also on a RSN, but we have that agreement directly with the RSN. So we may or may not have been exploring what it could look like down the road or if something were to happen. And we would need to handle that as an organization, but the league would be there to help, but we would take ownership over those agreements with whatever potential local broadcasting network it would be. I will say, though, I agree with both my colleagues that DTC is at the forefront of all of it and is the likely candidate to keep pushing forward.
Time for one more quick question, if anyone has it. Or else we can end right there. Let's give our panelists a round of applause. And we'll be back just with a few concluding remarks here in a sec. All right, so thank you again to everybody for a great day, including our final panel here. Just some brief thank yous. First to all of the speakers. Let's give them another round of applause. Thank you to the symposium committee as well as the rest of the Law Journal staff. Xander in the back has made sure that we're sounding good throughout the day. Devin, our event manager, made sure everything was set up great for us today. Carrie, taking photos and helping with the programs, is in the back there. Also, thank you to our security guards who helped us throughout the day, catering, and the rest of the event staff. And also a big thank you to Professor Grunardo. Could not have done this without him, and he's been a pleasure to work with this entire time. So with that, I'll turn it over to Professor Grunardo to close us out.
Don't worry, it'll just be 15 more minutes. Kidding. Thank you to Carrie, Xander, Devin, all our speakers who are still here, but most importantly to all the law students here, including all the ones on the Law Journal. I've had a number of panelists say how impressed they were with your attentiveness. You heard from some of the panelists themselves, but you make us proud, everything that you do, and it's why we're here and why we love being here. So thank you so much for everything. Have a great weekend. Enjoy the weather. Thanks, everybody.